le Sénateur Moore.
Présent.
Monsieur le Sénateur Pallett.
Présent.
Monsieur le Sénateur Mezek.
Présent.
Monsieur le Connétable de Saint-Hélier.
Présent.
Madame le Connétable de Saint-Laurent.
Présente.
Madame le Connétable de Saint-Sauveur.
Présente.
Monsieur le Connétable de Saint-Brelade.
Présent.
Monsieur le Connétable de Grouville.
Présent.
Monsieur le Connétable de la Trinité.
Présent.
Monsieur le Connétable de Saint-Pierre.
Présent.
Monsieur le Connétable de Saint-Marie.
Présent.
Monsieur le Connétable de Saint-Ouen.
Présent.
Madame le Connétable de Saint-Martin.
Présente.
Monsieur le Connétable de Saint-Jean.
Présent.
Monsieur le Connétable de Saint-Clément. Madame le Député Martin.
Présente.
Monsieur le Député Southern. Madame le Député de Grouville.
Présente.
Monsieur le Député Lewis.
Présent.
Monsieur le Député Tadier. Monsieur le Député Higgins.
Présent.
Monsieur le Député Masson.
Présent.
Madame le Député Pinel.
Présente.
Monsieur le Député de Saint-Martin.
Présent.
Monsieur le Député de Saint-Ouen.
Présent.
Madame le Député Dublé.
Présente.
Monsieur le Député Labbé.
Présent.
Monsieur le Député Wickenden.
Présent.
Monsieur le Député de Sainte-Marie.
Présent.
Monsieur le Député Truscott.
Présent.
Monsieur le Député Young.
Présent.
Monsieur le Député Ash.
Présent.
Monsieur le Député Morel.
Présent.
Monsieur le Député Guida.
Présent.
Monsieur le Député de Saint-Pierre.
Présent.
Monsieur le Député de la Trinité.
Présent.
Monsieur le Député de Saint-Jean.
Présent.
Madame le Député La Hégara. Monsieur le Député Ayer. Madame le Député Pershar. Monsieur le Député Ward.
Présent.
Madame le Député Alves.
Présente.
Monsieur le Député Pamplin.
Présent.
Madame le Député Gardner.
Présente.
Monsieur le Doyen.
Notre soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et la puissance de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien et au soulagement du peuple, qu'il te plût de commettre à leur soin. Car nous t'en prions au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite dans la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi est le règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le Sénateur Gorst.
Présent.
Monsieur le Sénateur Lafondre.
Excusez.
Sir, the Chief Minister is having a slight technical glitch, but he is present in the chat.
Very well, thank you.
Monsieur le Connétable de Saint-Clément.
Excusez.
He's in the chat.
In the chat?
Yeah.
It's in the chat. I'll mark as present.
Monsieur le Député Tadier.
Excusez.
Monsieur le Député Ayer.
Présent.
Madame le député Pershar,
Malade.
vous jurez que Madame le député Pershar est tellement indisposée qu'elle ne peut pas assister aux États sans exposer sa santé.
Les États sont constitués. We now resume the debate on P95, assisted dying. And next listed to speak, I have the Connétable of St. Peter. Connétable, you able to speak?
Thank you, sir.
Yes.
I would like to thank all those who have contacted me over the past few weeks. I don't recall any debate which has generated the volume of contact from islanders expressing their views for and against a proposition. I have also undertaken my own research, looking in particular at the legislation introduced in Australia, together with a report a year later into the introduction of the law and issues that had arisen. I also looked at the scheme available in the state of Oregon in the US. I do believe that an individual who has an incurable disease and is faced in their final months with the prospect of unbearable pain should have the right to decide how they die. However, the definition of an incurable disease is not without its problems. Over 40 years ago, a relative of mine was given 6 weeks to live with an incurable form of cancer. They were lucky that the doctor involved did not give up on them and found pioneering treatments in the US, which had not been performed in the UK before. I'm pleased to say that that person recently celebrated their 91st birthday. My conflict was whether the proposition in front of us would offer sufficient safeguards. Without the detail necessary to give me the assurance I required, I felt I could not support the proposition. And I'm thankful that an amendment was lodged, which will allow us, or those of us who are part of the new Assembly, to review those safeguards at a later date. The amendment has allowed me to support the in-principle proposition. Coercion is a serious issue, and there is evidence to suggest it has occurred in some jurisdictions. It is something that I had come across in my career in banking. In some cases, it is so subtle to the extent the victim is not aware it is occurring. Almost exclusively, it occurred towards the end of someone's life and involved their estate. Adult children may have inheritance impatience, which has been an issue noted in Australia. In Oregon, in the United States, where assisted dying has been available for over 16 years, 50% of those requested assisting dying stated as a reason that they had become a burden on others. One would have to question how many of these people had reached that conclusion with the assistance of others. In addition, in that state, doctors are not permitted to raise the question of assisted dying with patients unless the patient raises it first, which is a safeguard I would endorse. It is therefore essential that the controls we put in place are extremely robust. It will not be easy for those who have to undertake that task to set safeguards and provide 100% certainty that issues such as coercion have not taken place, but they must protect the vulnerable and elderly to the greatest possible extent. The Oregon model allows doctors to prescribe lethal medication to the patient, but it is the patient's decision whether to take the medication. It therefore requires a positive act by them before the decision to end their life. The records show that in some years, nearly 50% of patients failed to take the medication, although the reason why this was the case is not given. Some will have decided that simply could not take that decision. Some may not have experienced the level of pain they anticipated. Others may have died naturally without the need for medication. Nevertheless, they were given the choice to end their lives in the way they wished to do so. The Oregon model is one I would favour. The Constable of St. Juan has already expressed his views on euthanasia, where another party administers the medication, and I share his concerns. It is important that doctors and our healthcare workers are not put in a position where they are forced to take part in procedures related to assisted dying. In Victoria, in Australia, one of the issues raised and reported on in the first year was that there was a shortage of doctors willing to undertake the procedures. Again, the legislation, when and if it is brought back to the Assembly, must be robust in this area and offer the highest level of protection. Had it not been for the amendment, I would have voted against this proposition. But an agreement in principle will allow us to review the matter when the level of detail that this subject deserves is in front of us, and to accept or reject the proposition on that basis. I do not wish to repeat matters raised by previous speeches, so I will leave matters here. Thank you, sir.
Thank you very much, Contab. Deputy of Grouville.
Thank you, sir. I'd like to thank everyone that's written to me, emailed, phoned. We've had, I think, an unprecedented amount of correspondence on this particular issue. I was very moved by what the Dean spoke of yesterday in his excellent speech. He spoke about compassion, and I totally agree with what he was saying, but he was speaking about the voices that speak the loudest. And in this particular subject, I'm not sure which voices are currently speaking the loudest. Also, during yesterday's speeches, Deputy Doublé raised an issue about coercion. And as a society, I think it's something that we really need to give greater focus to, because it's not just in this particular case where the fears could be raised. There's all kinds of coercion that could be taking place, and I think that it is something that we need to look at when we're persuading. You know, people can be persuaded to leave their homes as they get elderly, to give up control of their finances, to go into care. What safeguards have we in place in our society to ensure that those people aren't being coerced and making decisions that and doing things that they really don't want to do? So I would say that we really need to look at the issue about safeguarding across our society. So this is such a difficult subject, and like many others, you have a particular position, or you think you do, and then you hear another viewpoint and you totally agree with their viewpoint. But at the end of the day, we've got to make a decision. So many of us, I believe, are drawing on our own experiences, and it's do unto others as you have done to yourself. And that's when I can draw on some of my own experience, witnessing my husband's brother suffer over about 3 years. He had Alzheimer's, and he lived in Scotland, and every time my husband and I went up to see him, he was worse each time, and we witnessed this proud man, a fine, proud man, being reduced to a shell of a person. And it wasn't the care. He was cared for in his home. It wasn't the amount of care. My husband comes from a family of 12 brothers and sisters, so there was plenty care to be had. But for me, his quality of life, his existence deteriorated so much, so badly. It was utterly heartbreaking to witness. And you would draw from it and think, would I want to be in that position? Well, obviously nobody wants to die, but would you want to have to live or exist in that way? And the answer has got to be no. And for me, it moved me so much. On the last trip up to Scotland, I came back to Jersey, saw my solicitor, I made a living will and I handed it out to each of my children and my husband and said, I do not want to ever be in that position. But that's my choice. That's my choice. And I perfectly understand those who are for religious grounds, humanist grounds, conscientious objectors in the medical profession. I perfectly understand they too have a choice. But I don't want to deny the choice to people that don't want to go through any suffering or just be reduced to such a poor existence. It is not worth living. There is another aspect. By not granting this choice to people in Jersey, is that if we deny people that actually want this choice, we are forcing them to leave and go elsewhere to take up a Dignitas type end to their own lives. And I don't think that is right either. I think that what you've got to sort of consider what they would have to go through. And obviously it would only be open to those that can afford it, to move over to a clinic elsewhere, to stay there. At what stage do they travel? Do they've obviously got to be compos mentis to take the aeroplane or however they're getting there. So at what stage? Is it 6 months before they die? Is it a year before they die? And what about their family members? So what we are actually doing is denying these people the right to be at home, to be surrounded with family. And I don't think that is right either. So as a jurisdiction, this proposition has come before us, and I think we've got to consider it, and we've got to consider every single element of it. And by not implementing it, what we are actually subjecting people to who want and can afford the choice to go away. I knew Alan Dishma very well, and I feel that he was an incredibly intelligent, level-headed, fun-loving person. And he, in the cold light of day, made a choice. He didn't need to exercise it in the end, but I know he took great comfort just knowing, as the Constable of St John described yesterday, as having an emergency exit, where just knowing that he would not be subject to existing or great suffering at his end. So for me, I am going to support the proposition. Like others, I'm incredibly grateful to Deputy Morell for bringing his amendment, because I think we will all be able to reflect on this further. And when we do, I really hope that the coercion element is not only considered in this particular element, but this particular subject, but others too. Thank you, sir.
Thank you very much, Deputy. Does any other member wish to speak on the proposition? Deputy Alves.
Thank you, sir. I think a lot has been said already in this debate, and I'd just like to add my thanks to everybody else's for all those people who have emailed me. This is quite a difficult thing for me, sir, because I was brought up Catholic and have considered myself Catholic most of my life. So my decision on whether to support this or not ultimately comes down to faith versus experience. And so I believe that faith is what guides us, but experience often changes and shapes us. As a member of the Health and Social Security panel, I'm going to just draw into some research we've done to assist us with our work on mental health over the past 3 or so years. And I just want to start off with some facts and figures around suicide, as this was something that's been mentioned quite a lot in this debate. And I want to start by quoting the Samaritan Guidelines to all public bodies. And what it says there is, speculation about the trigger or cause of a suicide can oversimplify the issue and should be avoided. Suicide is extremely complex, and most of the time there is no single event or fact that leads someone to take their own life. However, excessive use or coverage of suicide can lead to irrational suicide behaviour amongst vulnerable people. For example, in the 5 months following Robin Williams' suicide in 2014, there were 1,841 more suicide deaths in the USA compared to the same period of time from the previous year. That's a 9.85% rise. So there's absolutely no peer-based medical evidence that assisted dying undermines or runs counter to affect suicide prevention strategies, nor is there evidence to suggest that the legislation of assisted dying has led to a shift in attitude towards suicide. It's also important to stress the difference in each country, like Belgium and New Zealand, for example, with their different policy and laws on this area. If you compare the suicide ranking of US states between 2005 and 2017, you'll note that nearly every state that passed laws authorising medical aid in dying dropped in the rankings after they passed. Western states have higher suicide rates than the national average because they have higher gun ownership rates, and access to mental health care services in many of those rural areas are grievously lacking, including states where medical aid in dying is not currently an authorised option. The rate of euthanasia in the Netherlands has remained fairly stable at 2.8% of all deaths in 2010. The most recent survey of doctors in the UK was in 2007 to 2008, and the rate of euthanasia was reported to be 0.21 of all deaths, and a similar rate has been reported in France, even though euthanasia remains illegal in both countries. In contrast, research carried out in Belgium found the rate prior to legislation was unclear, with separate surveys reporting 0.3 of all deaths in the region in 2001 to 2002 and 1.1% in 1998. The rate has risen steadily since legislation in 2002 to 4.6 of all deaths in the most recent survey in 2013. So very low rates of assisted suicide are reported in countries that both permit and prohibit this practice. So my mother is a carer, and she's been one on and off since I can remember. At the time of my birth, she was a living carer, and I have many fond memories of the various people my mum has cared for in the past, many until their final days. So inevitably, we spoke about this subject a few days ago and how I would be voting. We spoke about pretty much everything that's already been brought up during this debate, so I won't repeat anything that's already been said. The main concern for both her and I was around those without capacity whose decision would be put into somebody else's hands. And although this is a debate on the principle of assisted dying, it is clear from the conditions and criteria set out in this proposition that only the person themselves would be making that decision. And like many who have spoken, sir, I'm extremely glad that Deputy Morell put in his amendment, and that these specific conditions and criteria are in this proposition that we're debating now. Because without these safeguards, sir, I would not have given any consideration to supporting this. Overnight, we received an email from Sarah Wotton from the Dignity in Dying organisation, and I'd just like to quote what she said regarding safeguarding. The proposition already contains an outline of safeguards that are common to other jurisdictions that have legalised assisted dying, whether in the USA, Australia or New Zealand, which all have assisted dying laws in place. In none of these jurisdictions have there been cases of abuse. Rather, laws have been proven to work safely, providing choice and control to dying people while protecting those who do not wish to have assistance to die. It should also be recognised that the law in Jersey at present provides no safeguards except for the threat of prosecution after a person has been assisted to die. In the UK, we know that the effects of this blanket ban are terrible for dying people and their families. It forces people with terminal illnesses to travel to Dignitas if they have the financial means, are well enough to travel and can access the necessary documentation. For those unable to travel overseas, hundreds of people in England and Wales take their own lives by suicide while living with a terminal illness. Thousands of people every year die without adequate pain relief at the end of life, die without dignity, or while suffering from unmanageable symptoms. If we are serious about safeguarding vulnerable people, the answer is not to maintain an unfair, uncompassionate and unsafe prohibition on assisted dying, but to provide that choice with robust and stringent eligibility criteria. Banning assisted dying does not prevent it, it merely moves it into the shadows. So there was also something else that was mentioned in this email that I think is important to put on public record, especially since many people have questioned the validity of the selection process of the citizens' jury, for example. So in this email, it was mentioned that we know the people of Jersey to be overwhelmingly in favour of a law change. Polling carried out in May this year by the Island Global Research, Channel Islands polling specialists, found that 90% of islanders agree the law should change to allow terminally ill, mentally competent adults the choice of an assisted death, including 73% who strongly support law change. Furthermore, 54% said they are likely or very likely to consider travelling overseas for an assisted death if they were terminally ill, and just 3% believe that Jersey should wait for the UK to act first. So in my mid-20s, I was fortunate enough to be able to buy a home, and as a result had a will drawn up. It's a strange thing to do when you're in your 20s and otherwise healthy, but I thought it was sensible. I remember having the conversation with my partner at the time about death and what would I want in the event of my death, etc. And inevitably we got onto the subject of terminal illness. I told him that if we got to that, if I was suffering, I would not want to prolong my life. And if that meant taking my savings and going abroad for it, then that's what I would like to happen. Ideally, sir, I would rather not have to go elsewhere to die peacefully. This is my home and I would want to stay at home. But if this wasn't an option, I would rather go elsewhere than suffer and let those around me see that suffering. I don't want somebody's last memory of me to be a traumatic one, and I should have that option available to me. So I said at the start of my speech that I was brought up Catholic, and although I haven't always practiced many parts of this religion, there is one thing I have lived my whole life by that I have taken from it, and that is do to others as you would have them do to you. This proposition is about choice, and I would never want anyone to restrict my choices on something that impacts me and my body. Regardless of my faith, I have no right to do that. So with that, sir, and based on the fact that safeguards outlined are in place and that the detail will be coming back at a later stage, I will be supporting this proposition. Thank you, sir.
Thank you very much, Deputy. Does any other member wish to speak on the proposition? Does any other member wish to speak on the proposition? If no other member wishes to speak, if no other member wishes to speak, could members leave the approbation and comment until after I've been clear that no one else wishes to speak, please? It may be blocking other people who wish to indicate. Does anyone else wish to speak on the proposition? No one else wishes to speak on the proposition? Then I close the debate and call upon the Minister to respond.
Sir, I would like to thank all members for their contribution. I can see that some of these were difficult or even painful, and I am glad that the subject was treated with the dignity it deserved, and also that no one shied away from it. I will not argue with them on the principle, so my responses will only be about the draft safeguards within the proposition and how we designed them. It will also be about the data used in some of the representations. To the Constable of St. John, who would have liked to be presented with both sides of the argument at the same time, these meetings were of course organized by opposing sides. As the government wanted to remain neutral in principle, it is not something we wanted to organize. It was, however, one of the principles of the citizens' jury that they would be exposed repeatedly to advocates from both sides. The Deputy of St. Martin said that the report answers all questions, but that there is lots of work left to do. I can only agree, of course. For an in-principle decision, there was a huge amount of work put into it already, and I would like to thank all the officers who participated in the creation of these documents and the long process that led to them. Deputy Morel's amendment will allow the Assembly to follow and participate to this work in addition to deciding upon its results. The Constable of St. Ouen and the Constables of St. Peter asked for a separate vote on Part A, Roman numeral 2(1), and A, Roman numeral 2. I am really wary that the fear of not having the option of voluntary euthanasia may tempt people to choose physician-assisted suicide much earlier than they would need to. I would normally be very open for other states members to alter a proposition, but in this case, I will not offer this option, which I think removes an important safeguard. If we want to allow assisted dying, it needs to remain an absolute last resort, not a choice you need to make early. Senator Ferguson suggested first that the citizens' jury has been self-selecting in favor of assisted dying. The jury was selected through an independent and random sortition system. This ensured that they matched the distribution of the whole population, especially in their position on assisted dying. The source of the statistics used is indeed the British Social Attitude Survey, the result of which has been remarkably stable over the last 40 years. Since 1983, every single year, 80% of the randomly selected British people in it have been in favor of assisted dying. It would have made no sense to use any other figure. The Deputy of St. Ouen suggested that the proposition accepts that vulnerable people will be put at risk. The proposition, in fact, accepts that there is a risk for vulnerable people and then describes many possible safeguards which are designed almost exclusively to protect them. We have now given ourselves 18 months to develop these safeguards to the best of our ability and under the control of this and the next Assembly. One of these standard safeguards is that health professionals cannot be the ones to raise the issue of assisted dying of the patient. The patient must raise it first. Finally, there is no reason why the introduction of assisted dying should have any influence on the provision of palliative care. Right now, the Director of Palliative Care at Jersey Hospice is developing a new end-of-life strategy which will bolster the island's palliative care offering. We only need to support him. Deputy Doublé expanded on the subject by mentioning care at home and the expected role of women in it. It is an important subject that we must also tackle in our future care model. Deputy Morel expressed concern about life-ending medications. He referenced an old unreviewed study about American capital punishment by lethal injection. It bears no relevance to the practice of assisted dying, where sophisticated combinations of drugs are used to ensure a safe and painless end of life. With regard to the rib fracture incident, the patient already had cancer, renal failure, and dementia. Furthermore, the clinicians were unaware of her fall. Clinicians made a serious mistake, but one which would have hastened their days by only hours or possibly days. The professor who reviewed the case said, "It would have been unacceptable, undignified, and negligent to have left her pain and distress unmitigated, even if the unintended and unlikely effect may have been a death some hours sooner than without it." The deputy also said that suicide rates have been shown to increase in jurisdictions where assisted dying has been introduced. There is evidence that rates have increased in the US as a whole nation, not especially in the states where assisted dying had been introduced, also in the Netherlands. But on the other hand, rates have declined in Belgium and Canada. There is still no proven causal link with assisted dying. To Constable Vibert, there is already in the proposition a consensus objection clause to ensure no medical professional is ever forced to participate in assisted dying. I would like to finish by presenting my personal views on assisted dying. Like all in this chamber, I have received many personal representations on the subject, but I have been unable to answer them so close to the debate. I would like to apologize to those people for that, and I will now explain my own position. I will be voting for assisted dying. I will do it in the knowledge that I will disappoint the people who have written to me to advocate against it. But this vote is not for them. My vote is not for the pressure groups, the lobbyists, or the advocates of assisted dying. I am voting on behalf of a single person. She's a phase 4 cancer sufferer. I am voting for that one person who was in such pain that the only way to alleviate it was to make her unconscious for a week. A person whose very short future is overwhelmed by the fear of this pain returning. Overwhelmed by the fear that her last contact with her family will be through screams of agony until she is rendered unconscious again. Her relatives will sit by her inert body for days or weeks until her heart mercifully stops beating based on its own unfeeling biological process. At this point, she will probably be alone. I am voting to give that one person one merciful, decent, dignified option if she chooses to use it. Sir, I ask for the appel.
Very much, Deputy. I took it from your speech that you wish to take the entire proposition together and not to divide the parts. Is that correct?
Yes, please, sir.
That is a matter entirely for you. Before I put the matter to the vote, I hope members will not mind me saying that it is always a privilege to preside over this assembly, but it has been a particular privilege to preside over this debate. Members have brought their best reflective selves to the debate, and it has been of absolutely the highest quality. So, as I say, it has been a particular privilege. I ask the greffier to place a voting link into the chat, and I open the voting and ask members to vote in the normal way.
Sir, given the importance of this vote, I wonder if we could just have a bit more time just to make sure that the system is working.
Yes, we will, and I will go as slowly as I hope members could hope. Well, if members have had the opportunity of casting their votes, I will shortly close the voting. So anyone who has had any difficulty might wish to participate in the chat now. Very well, if members have had the opportunity of casting their votes, I will ask the greffier to close the voting. The proposition has been adopted. 31 votes pour, 9 votes contre, no abstention in the chat, and a further 5 votes pour and 1 vote contre in the link. The contre? Very well, all votes.
Those voting in the chat in favour of the proposition, the Connétable of St Saviour, Deputy Pinnell, the Senator Moore, the Deputy of St Mary, and the Deputy of Trinity. And in the link, Deputy Labby, Ayer, Senator Lafondre, Valois, Deputy Ward, Deputy Pamplin, Deputy Lehegara, Deputy Truscott and Higgins and Doublé, Senator Mezek, the Connétable of St Martin, the Connétable of St John, Deputy Martin, Deputy Alves, Deputy Gardner, Wickenden, the Connétable of St Juan, the Deputy of Grouville, the Deputy of St Peter, Senator Farnham, the Deputy of St John, Deputy Morrell, Deputy Southern, the Connétable of St Clement and St Peter and Grouville, Senator Pallett, Deputy Guida, Deputy of St Martin and Deputy Masson. And those voting contre in the chat, the Connétable of St Lawrence, and in the link, the Connétable of St Helier, the Connétable of St Brelard, Senator Ferguson, the Deputy of St Juan, Deputy Young, Deputy Ash, the Connétable of Trinity, and Senator Gorst.
Very well. I was at this point going to move on to an urgent oral question, but the greffier is considering the answers already given by the Minister yesterday, and so we will revert to the order of business and I'll intersperse it possibly at a later time. We now come to P94, which is the principles for Jersey's participation in the United Kingdom Free Trade Agreement, and it's been lodged by the Minister for External Relations and Financial Services. For the purposes of this debate, the main respondent is the Chair of the Economic and International Affairs Scrutiny Panel, and I'd ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to adopt the following principles upon which the Council of Ministers shall determine Jersey's participation in future United Kingdom free trade agreements. A. Protecting Jersey's existing constitutional autonomy and cultural heritage. B. Maintaining and strengthening Jersey's reputation as a well-administered jurisdiction that is responsible for its own prosperity. C. Upholding the long-established rights and privileges of Jersey residents and businesses that enable them to trade and remain agile, innovative, and competitive as Jersey seeks to grow and diversify its economy. D. Maintaining or increasing the ability of the State Assembly and Government of Jersey to make decisions expeditiously in areas of domestic policy, including where close collaboration with the UK Government and other international partners is required. E. Further to the current baseline of customs and goods participation, seeking the inclusion of extension provisions to enable Jersey's participation in additional provisions post-ratification, and where extension includes the basis of new commitments, obtaining the consent of the States Assembly wherever practicable, or otherwise reporting to the states at the earliest opportunity. F, taking into account commitments already undertaken in existing free trade agreements which Jersey participates in. And G, keeping the relevant scrutiny panel informed and up to date on all free trade agreement negotiations with which the Government of Jersey is involved.
Well, Minister.
Thank you very much, sir, and I thank members for agreeing yesterday to take this after the preceding decision. As members will be aware, since the United Kingdom became an independent trading nation at the start of this year, the UK government has been negotiating a series of free trade agreements, which I will refer to as FTAs, with countries around the globe. The UK has an ambitious global trade agenda, which has been largely focused on negotiating new FTAs that were not in place when the UK was an EU member state. That said, the agenda also includes enhancing FTAs that were rolled over, known as continuity agreements that were in place when the UK was a member of the EU. They have sought more comprehensive trading provisions within continuity FTA agreements, and some of these have already been secured with partners including Japan and countries forming the European Economic Area. As a Crown dependency and a proud member of the British family, Jersey can benefit from the development of this network of global free trade agreements. Members will, I hope, recognise that securing our own separate FTAs with larger countries such as Australia and Japan would be extremely challenging. In the view of the Council of Ministers, it's both logical and sensible for Jersey to take advantage of our position in the wider British family when it comes to global trading arrangements. It is therefore the clear view and recommendation of ministers that, in line with our ambition to maximise potential opportunities for Jersey throughout the Brexit process, Jersey should be seeking participation within FTAs from the outset. This proposition accordingly results from the need for Jersey to determine the principles on which we wish to negotiate our own participation in these new trading arrangements, and from the desire of ministers to ensure that the Assembly is properly involved in this area of work and to the greatest possible extent. To date, it has been possible to secure this participation in the goods chapters of continuity FTAs, assisted by the UK Jersey or CD Jersey Customs Union being in place. These are arrangements from which Jersey largely already benefited in previous years, with the notable addition that we have secured mechanisms to allow for broader participation in the future, primarily in service chapters where it is in our best interest to do so. Members will appreciate that the nature and mechanisms of a negotiation inevitably means that they go down to the wire and are undertaken confidentially, something which Jersey has always meticulously respected. Indeed, it is vitally important for our international credibility that we continue to do so. It is also the case that the text of an FTA is not publicly available for scrutiny in the UK Parliament until after it has been signed. The States Assembly process accordingly needs to align with this wider process, which means that members will get sight of text at the same time as the UK Parliament. The consequence of this process means that if Jersey wants to benefit from coverage from the outset in any new FTAs, we must reach a decision on participation before the text of the FTA is signed. That is the reality of international trade negotiations, a relatively new world for not only the UK, but of course for Jersey, and one that needs us to make specific internal democratic arrangements. The proposition then, sir, if adopted, looks to address these challenges as far as it is possible in respect of securing the Assembly's role in this important policy area. It secures the key principles upon which the government will be participating in the UK's negotiations. This ensures that the parameters within which ministers can act are set rightly by the Assembly and sets a number of safeguards for members. This is especially important now that we are moving towards brand new trading arrangements being finalised, those that aren't continuity FTAs. I believe that these objectives are achieved through this proposition. I recognise, as I've said, that this is new territory both for the Government of Jersey and for this Assembly. The proposition therefore seeks to proceed with a pragmatic approach whilst allowing for ongoing flexibility. The proposition's guiding negotiation principles are built upon the Brexit negotiating principles, which members will be familiar with. These have been deliberately chosen as a starting point in order to provide continuity in our approach to all FTAs. The guiding principles also take into account commitments which Jersey has undertaken in continuity trade agreements already, so as to ensure consistency with our existing trading relationships. The principles essentially provide the parameters for the government to determine Jersey's day one customs and goods involvement. They also include a proposal for extending services and investment chapters post ratification. As members are aware, Jersey already participates in the customs and certain goods chapters of certain FTAs, including the Japan and, as I've said, the EEA. These agreements maintained the principle of goods participation, which Jersey was previously privy to under Protocol 3 before the UK exited the EU. Jersey's participation in the customs and goods provisions of an FTA brings with it the advantages that the UK has negotiated. These generally include the application of preferential tariffs, quotas and border measures to facilitate cross-border flows of goods. Whether Jersey participates in an FTA or not, Jersey still applies the UK global tariff on imported goods. This is because of the UK-Jersey customs arrangement, which ensures free movement of goods between us. As I say, that is mirrored across the other two Crown dependencies. It must be emphasised that should Jersey decide not to participate in a particular FTA, Jersey exporters would not benefit from the liberalised tariff lines that treaty partners benefit from, putting our exporters at a disadvantage with any competitors they might have in the United Kingdom. With respect to services and investment provisions of FTAs, these include many international obligations which are new to Jersey and which operate in areas of greater economic significance for our island. The guiding principles propose that the UK always seeks to secure an extension mechanism for other chapters beyond customs and goods to utilise post-ratification, allowing time for further assessment once the agreement is finalised. This mechanism, as I've mentioned, has been negotiated in other FTAs. Members will appreciate that each FTA is a separate negotiation, and as such the outcome cannot be entirely guaranteed. It unfortunately may not always be possible to negotiate an extension mechanism. The key advantage, of course, of an extension mechanism is to allow Jersey to consider further obligations in slower time and on the basis of the final text. Where appropriate, this will allow the government and states members to assess and scrutinise participation in other FTA chapters. The proposition as a whole preserves and enhances the ability to refer FTAs to the States Assembly for consideration and debate where, of course, it is practicable. It is especially appropriate that the Assembly is given a particular opportunity to review any new commitments proposed by the government. Accordingly, unless it is entirely practically unfeasible, it is my policy intention for any new commitments around service inclusion to come back to the Assembly for specific approval. The proposition nevertheless deliberately builds in sufficient flexibility for scenarios where, even with the best of intentions, parliamentary debate, even on a new commitment around services, isn't absolutely possible prior to ratification. Such circumstances, the government would be required to report to the states at the earliest opportunity to update on the agreement which is signed. Members, I hope, will be further reassured that additional checks are built in through the requirement to keep the relevant scrutiny panel updated on live negotiations with which Jersey is involved. The Economic and International Affairs panel has accordingly been consulted on these principles and is kept updated on the current FDA plans that are underway. This engagement will continue, and I am extremely grateful, sir, to the chair and to the panel for the cooperative work that they have undertaken whilst we have been participating in these negotiations, and I can't thank them enough, sir, for that cooperation. Members should also note that this proposition sets out an approach which is appropriate for Jersey at the present time. Given that the UK FDA agenda and process is relatively new, I have no doubt that the government and the Assembly will want to review our opening position over the longer term, particularly when Jersey has successfully utilised this extension mechanism, which may take some time. This means, to be clear, that this proposition should, and I think will be, updated in due course by ministers and brought again for approval. Having it on record, of course, allows any member or panel to bring their own amendments if they think a future government is being slow to act. One future option, by way of example, might be broader day one coverage. Should Jersey have successfully extended similar services and investment provisions in other FTAs, we would have a better understanding of the practical impact of services participation in a new FTA. This then could become Jersey's new baseline if we so wished. Before closing, sir, one key point to stress is that by accepting these principles, the Assembly will not erode the existing constitutional requirement for Jersey's formal consent to be given prior to participation in each and any new FTA. Whilst we wish to start from an assumption of seeking inclusion, ministers will continue to assess each FTA on a case-by-case basis. Ministers will not agree for Jersey to sign up to an FTA or up to FTAs which are not in the island's best interest. This proposition ensures that the views of ministers in this respect can continue to be subject to the required democratic scrutiny. So this proposition, whilst being novel and new, ensures that the Assembly is cited in advance on the government's ongoing approach to inclusion in the UK's future FTA programme. The guiding principles, if adopted, will provide a democratically endorsed position for future FDA participation and contribute towards strengthening the UK's negotiating hand when convincing a trading partner of the importance of Jersey's position. They appropriately balance Jersey's internal constitutional arrangements, the need to involve the Assembly in this key policy area and maintain democratic oversight, and the reality of international trade negotiations. So we have always sought to ensure the involvement of the states in the Brexit process and beyond, and I believe that this commitment to do so is maintained by this proposition if it's to be adopted today. It will, of course, as I've tried to indicate, potentially be a living document, but one whereby the states and Assembly will rightly be involved where changes are proposed in the future. I and all of my colleagues in external relations endeavour always to act in the best interest of the island, in the best interest of our government, and in the best interest of this Assembly. I ask, sir, for the Assembly's continued support in our efforts to develop Jersey's international personality in the interest of all islanders, be they individuals, families or businesses. And I move the proposition, sir. Thank you.
Thank you very much. Minister, is the proposition seconded?
Yes, sir.
Yes, sir.
I then open the debate and call upon the Deputy of St Mary.
Thank you, sir, and I thank the Minister for his presentation. I simply wish to advise members that the Economics and International Affairs Scrutiny Panel did have a presentation from the Minister and his team to explain what was being put forward. And in fact, there's very little we can add to what is contained in the report or the address just given. One item I would like to highlight is that, as the Minister has just said, the Minister is scrupulously fastidious about keeping the panel informed as to any agreements. We are informed, often at short notice, but that is not a problem to us, of any forthcoming matters. We are fully informed, and we do obviously accept that the rules as to engagement with Westminster on occasion prevent matters being public. The panel takes that responsibility on board, and as I say, sir, appreciates the fact that the Minister does all he can to inform the panel of the current state. On that basis, I think I have nothing further to add other than to say that the panel does of itself approve the approach and will support the proposition. Thank you, sir.
Thank you very much. Deputy Young.
Thank you, sir. Thank the Minister for his detailed statement, much of which I think is of a very, very technical nature. I wanted to just address what I think is a lay question that may be in people's minds. Obviously, we know the abandonment of our Protocol 3 as a result of Brexit, and now the substitution of an arrangement whereby we have the opportunity to participate in free trade agreements that the UK may do, as it were, going on their mission to bring the world into their territory, as it were. I think the issue for me as the current Environment Minister is whether or not there's any potential conflict between these principles and our adopting these and the autonomy of Jersey to make individual decisions on certain matters. For example, I'm particularly thinking about food law, where we're bringing forward new rules under the OCR rules, which are required as part of our status as a third country, which will require a new food law, and also animal welfare. And I'm particularly here thinking of issues which are very much in the public domain about what is widely reported is the suggestion that the United Kingdom arrangements would open up the importation of hormone produced beef, of chlorinated chicken, automatically of any GM crops or anything of that nature. And indeed, one reads recently about animal welfare issues related to animal husbandry and export in other countries. And so those goods, we don't yet know what the UK agreements will be, but they may result in those items being in general supply with the United Kingdom. And I'd like to know whether or not Jersey if there's any conflict in Jersey's ability to make those choices in terms of our own domestic rules, for example, on things like food labelling and so on, about that. So I would like to hear the Minister's please confirmation that these principles don't get in the way of our ability in Jersey to be able to make individual decisions, sir. Thank you.
Thank you very much. Deputy Masson.
Thank you, sir, and I'm grateful to the previous speaker because I had similar concerns when looking at this particular proposition. Not that there's anything wrong with this proposition as it stands, and I thank the Minister for introducing this to the Assembly in the way that he did. It was very comprehensive, and I'm grateful to the Minister saying that, you know, this is a living document, because when reading through parts A to G, it struck me as what was, it's more what was missing than not what was there. It was more when we're entering these types of trade agreements, we shouldn't forget about ethics and community values, and particular, I think that particularly important with regard to the environment. Now we're looking at the climate change issues, and I was going to go into issues around animal welfare that the previous speaker went into, but also thinking about things such as patents. And I've said in this assembly before, where we have situations whereby thinking about intellectual property, where communities might have used the DNA of a plant for years and years and years, for centuries, but because that community doesn't have the patent on it, and a company comes along, owns the patent and forces that community not to use that plant anymore. Again, those types of ethical considerations are really important when we engage in these types of trade agreements, in order to ensure that dubious practices that our community wouldn't approve of, we have some sort of clause to protect ourselves under ethical grounds. So, sir, I wonder if the Minister, when summing up, might add eventually some sort of ethical consideration, because we're looking at the principles for Jersey, and for me that's missing in this. So I will be supporting this proposition, but I think in order to add value to this proposition, that should be perhaps explicit than where it is now. Thank you, sir.
Very much. Connétable and Brillard.
Thank you, sir. I have great difficulty in reconciling these proposals with the fact that Jersey fishermen have suffered significantly as a result of Brexit and the attitude of another government concerning the movement of our goods. Would the Minister confirm in his summing up that other parties in FTAs, whether they be our closest neighbours or furthest, will abide by similar terms with regard to trading with us? Thank you, sir.
I'm sorry, my concentration was slightly elsewhere. I'm not sure if you'd finished your speech.
Yes, I have, sir. Thank you.
A model of brevity. Deputy Morell.
Thank you, sir, and I'll attempt to follow the model set. I was wondering, I too share the concerns of Deputy Masson, Connétable of Saint-Brelade, and Deputy Young, and I would be grateful if the Minister could explain, particularly as Jersey in the main will be an importer as a result of these FTAs, as opposed to being an exporter. Our services industry obviously does export, and we do have export industries such as agriculture and fisheries, which are very important. But in the main, we will be importing from, we will be an importer of goods. And so I'd be very pleased to hear the Minister explain how, should we feel that certain products are not appropriate for this island, as was discussed in terms of ethics, animal welfare, etc., how we will be able to maintain control over the goods that we import, given the common travel area and the customs union with the UK that we have entered into, and the expectation from the UK that they will be able to export something, let's say, for example, from Australia, something that comes in which is grown in a way which we don't wish to import to Jersey, but it's come to the UK, and the UK can then export freely to Jersey. So if he could explain how we will be able to maintain control in that respect, I'd be very grateful. I'd also be grateful if the Minister could explain how he will ensure that economically entering into an FTA is the right thing for Jersey. How is that being measured? How are the impacts of these FTAs being modelled on the island's economy? And in the proposition itself, I note at the very beginning, it says Part A, protecting Jersey's existing constitutional autonomy. I'd be grateful if the Minister could explain why he decided not to include protecting and enhancing Jersey's existing constitutional autonomy. these FTAs could be used as a method for enhancing our autonomy, but it appears that the Minister has settled for just protecting. I'd be very interested to understand why he decided not to try and enhance our autonomy through these FTAs. And finally, sir, in my opinion, and the opinion of many other commentators, the UK is negotiating FTAs from a position of weakness because it has lost its largest market, and whilst it has the trade and economic cooperation agreement with the EU, it is clear, and the figures speak for themselves, that the UK has now lost, has a lower amount of trade with the EU than it had before. That lower amount of trade is not likely to be made up by FTAs with Australia, the Faroe Islands, even the USA. It will still be less. And so the UK is coming from a position of weakness because it is desperate to make up the amount of trade that it has lost. So how will the Minister ensure that Jersey's interests are properly represented by the UK, given that the UK is negotiating from a position of weakness, and indeed, I would say, desperation? Thank you, sir.
Thank you very much. Deputy Ward.
Thanks, sir. Just take this because it makes it sound strange. So a couple of things I'll just mention. In part D of the proposition, it says increasing the ability of States Assembly Government of Jersey to make decisions expeditiously, there's a word, in areas of domestic policy, including where close collaboration in the UK and other international partners is required. And just picking up on something that Deputy Morell just said, because I was wondering how to put it, but he put it well, in terms of the position of weakness of the UK in some trade deals, it could leave us open to more trade with what might be called more questionable jurisdictions. And so therefore, can I ask the Minister to assure the Assembly that what this does is gives us an opportunity to deal more with human rights records of those we trade with, to look more carefully at checks on the origin of goods and workers' rights in those countries where we source our trade, and the rights of peoples in those countries. So I would hope that the Minister can reassure that it gives us greater, if you like, autonomy to take account of those human rights records rather than simply relying on the UK, who some may say, quite rightly, in my opinion, they don't have a particularly great record when it comes to these sorts of things in some areas. Thank you, sir.
Much, deputies. Any other member wish to speak on the proposition? Senator Mezek.
Thank you, sir. And it is just very briefly, and it's to touch upon a similar issue that Deputy Morell raised, but probably from the opposite angle to him. And it's just to ask the Minister in his summing up to elaborate on the principles that we're being asked to decide on today and how that would prevent Jersey from seeking independence in the future.
Very much, Senators. Any other member wish to speak on the proposition?
Oops. Yes, please.
You're not able to use the chat, Senator Ferguson? Very well.
Sorry,
Senator.
I'm on my iPad and my chat sort of disappears and reappears occasionally.
Very well. Well, then please do speak. Senator Ferguson.
Yes, it was just to query, and perhaps the Minister could clarify this. Deputy Morell talked about the UK being in a weak position when negotiating. The last time I checked, the UK was actually a net exporter to the EU, and therefore the EU was more dependent on the UK than the UK on the EU. So perhaps the Minister could comment on that. Thank you, sir.
Thank you, Senator. Does any other member wish to speak on the proposition? No other member wishes to speak. Then I close the debate and call upon the Minister to respond.
Thank you very much. So difficult to know quite where to start with such a lovely lot of questions. So if I come to my colleague ministers first, as the Environment Minister knows, when decisions were made to be included in the post-Brexit deal, the questions that he has just reminded the Assembly of were the questions that he and myself considered and came to the conclusion that the TCA remained in our interest, particularly in light of the customs arrangements, and therefore I think the same can be said. I think the Minister was there when Council of Ministers agreed that this framework would be an appropriate framework, and these principles were appropriate, and officials answered his questions accordingly. There are, it's worth reminding ourselves, sir, that 95% of our trade is with the United Kingdom, and therefore the primary and most important arrangement is the customs arrangement, which secured that friction-free trade up into the United Kingdom. What that of course does by default mean that whether we were in an FTA with the UK or not, the UK would be seeking to sign FTAs with global partners, as I indicated, and therefore once those arrangements have been signed and agreed, those products and services flow in and out of the UK, and by extension goods flow in and out of not only Jersey but our fellow Crown dependencies. And I think there is a very strong argument, and really it applies to a number of the questions that members raised. There is a very strong argument that says that the greatest influence that we can have on some of the concerns that members raise is to be included and to make the case for what we believe to be right in those trade deals, and it's certainly what I've been doing. It's certainly what my officials have been doing. Sometimes so they've been pulling their hair out trying to do it, but that is what they've been doing, seeking to protect and enhance Jersey's interest in these negotiations. Deputy Massons mentioned environmental matters, and of course he's right to do so. What this framework and these principles do is deal largely, as I indicated in my opening comments, with goods, replicating the arrangement that we had with the European Union and the arrangement that we have with the rollover continuity agreements. But as I said in my opening comments, if we are to seek to have other chapters, of which environment is normally a chapter in itself, he makes excellent points that we would want to make, but I believe that it would be right for the government of the day to come back to the Assembly to seek inclusion in such chapters. That, of course, is why there is that proposal that I have made in my opening comments, and the same goes for his concerns about IP chapters, which would be covered normally in service chapters, and how they would rightly come back to the Assembly for inclusion before they were ultimately signed off for extension. So there are already protections in place, as the Environment Minister knows, that his officials deliver on, together with the officials in Customs and Immigration, that of course in Home Affairs and Treasury. that they deal with on a day-to-day basis. Those protections remain in place, and the Minister is seeking to bring in a new law to ensure they remain in place. So the Constable of St Brelard said that the Brexit deal was not in the interests of the Jersey fishing community, and I find that very difficult to understand, sir. I know that people have said it, sir. I know that people have said it, but just because it's said doesn't mean to say it is the reality. I see the reality very much that we are experiencing, and I'm open about this, great difficulty in the transition from the Bay of Granville Agreement to the TCA arrangements. But I am absolutely clear, and I think any fair reading of the TCA arrangements would recognise and accept the improvement that the TCA is for delivering a sustainable fisheries in Jersey's waters. There are difficulties, and I am the first to admit it, because I have officers in my office on a daily basis and communications on a daily basis, explaining what they are doing, and I instruct them of things to do in order to seek to alleviate those difficulties. The Constable of, there's some comment in the chat, sir, that fishermen have been sold down the river. That is absolutely not the case. Absolutely not the case. Fishermen and our fishing communities will, for the first time, have the ability to have a Jersey Minister making decisions about licences to be issued and making decisions about the sustainability of Jersey's waters. That was not the case under the Bay of Granville Agreement, and so we should not confuse transitional difficulties with what the actual trade deal says, and ministers are doing everything that they can to seek to alleviate those transitional difficulties. But we have to recognise that the reason that fisheries for us is so challenging is not about the overall trade deal and overall trade partners. It is simply about geography. Norman and Breton fishers have fished in our waters, as have Jersey fishers, for generations. And just as there were difficulties in reaching the Bay of Granville Agreement, which took 10 years to negotiate and alleviate those difficulties, we are experiencing difficulties now as we move to a new arrangement. But we really must keep the faith, work appropriately, pragmatically, and in the best interests of a sustainable fisheries into the future. That is what the Environment Minister's priority is. I support him in that priority, and if we hold our nerve, then I believe that we can get there, but it's going to take a continuing length of time. So we should not read across the fishing issue to all of the other potential FTAs or all of the other elements of the TCA, because our relationship with the European Union, of course, is not only governed by the TCA, but is far wider on areas like data protection, air security, and financial services. So I come to the other minister's comment about the economic interest of us signing up to FTAs. And he's, as an assistant minister in the economy department, working with the deputy chief minister in that department, knows the overarching framework work which his officers have been doing and which they continue to do. But I make the point again, I think, as I did when we had this conversation in the Council of Ministers when the Deputy raised it there, the point that it is surely in our interest to seek to be involved in these negotiations within the principles that I'll be asking members to support, because we can seek to influence the outcome of those negotiations and those FTAs, but without, then we are still affected by the imports that those FTAs agree to. And I think there has been a lot said in the United Kingdom about food standards and about the effect of on the farming industry in the United Kingdom. But this is where we, of all people, sir, in the legislature of a place like Jersey, which enjoys the autonomy that we enjoy, that enjoys the difference that we enjoy from the United Kingdom, shouldn't confuse a commentary in the United Kingdom. And I know, sir, that it's difficult because our media do. We often get phoned up and asked about what's going on in the UK and what does that mean for Jersey. And we know that the real answer, sir, is it means nothing at all because we are wholly different. But we are all terribly polite and we give some diplomatic answer. But surely, sir, members of this assembly know that the structure of our economy, the safeguards that we have around the rural economy and the structure of that rural economy is very different from that within the United Kingdom. I have nothing but praise, sir, for the work that Jersey Dairy does in its innovation and entrepreneurial spirit and the markets that it has sought around the globe out with these FTAs. And so there can only be greater and more opportunity for them, whilst at the same time, so we know that we have protections in place for them that we will continue to fight for. The biggest economic impact would, of course, be inclusion in service chapters, and that is not what these principles are seeking to ask the Assembly for, rather that we will return with them in the past. And I did take slight umbrage, sir, although I like Deputy Morel very, very much. I took slight umbrage for him suggesting that in paragraph A, protecting Jersey's existing constitutional autonomy and cultural heritage has been downgraded because we haven't added in the word enhancing it. I am absolutely clear, sir, that by being included in these FTAs, by very nature, enhances our autonomy. It enhances a global understanding of Jersey. It aligns with the work of the identity work that the Minister for International Development is doing. It shows to the world that we are a serious place and that we are a place which is good to do business with, and that we have something of importance to offer the world. And so by being included, it enhances our autonomy. But just in case the Deputy is in any doubt, of course, I believe that what we say use the word maintaining or increasing. So I hope that he can take comfort from that word there, increasing. Sir, I come then to Senator Ferguson. She is right, sir. Part of the debate during Brexit, we've yet to see whether it's going to materialise, of course, was that the UK is a net exporter. And I know that we all have a personal view on Brexit, and there are many in the Assembly who were, to use the UK parlance, Remainers. And I've been quite clear, sir, in defending Jersey's interests. I did not believe it was in our interest for the United Kingdom to leave the European Union, but that was a decision for the United Kingdom and the United Kingdom electors. But I remind the Deputy, sir, that rather than being weak and desperate, yes, they're politically eager, I accept that, rather than being weak and desperate, they remain the 5th largest economy in the world. And so if the alternative is that we would seek to negotiate FTAs with global partners ourselves, then I think that would be a true separation, which would prove to be much more difficult, rather than joining with the UK, defending our position, standing up for what we believe in, and standing up for Jersey's interests. So I don't quite see it in the terms that the Deputy has described in his questions. Do signing FTAs stop us from seeking independence? I think that's what Senator Mezek asked. Well, sir, I think this parliamentary state sitting must be a first in many respects. It was a first in the vote that we have just taken, but surely it must be a first with a suggestion from the leader of the Reform Party that we should be seeking independence. So I'm being frivolous. Of course, he didn't suggest that we should seek independence before he jumps on the chat, sir. But he wanted to know, in effect, that we were not doing something that would mean that we had less manoeuvrability to make decisions about our constitutional position in the future. And I do not believe that it does, because one of the issues that we are seeking in the negotiation of these FTAs, and perhaps this is an area where officials have been pulling their hair out, is for withdrawal mechanisms in the FTAs that Jersey could trigger itself. And that could be triggered for any number of reasons. But let me be clear, sir, whilst I believe in maintaining and enhancing our constitutional autonomy, it is in each islander's best interest. I do not believe that independence is in our interest. The relationship that we have with the Crown has served islanders well for centuries. And if we continue to enhance our constitutional autonomy, then I believe it will continue to serve us well for centuries to come. So I know that one or two members alluded to countries that they didn't particularly like for various reasons, and what the implications would be for FTAs. All of the issues that they alluded to, sir, are part of the considerations when signing any international treaty with those countries. And sir, our inclusion, again, in these treaties, I think, presents a platform during those negotiations to consider those matters. There has been a narrative, sir, of late that Jersey ministers don't consider those matters when they are in conversations with interlocutors in other countries. For my part, sir, I can say that I do. I don't make a song and a dance about it. I don't talk about it because those conversations come out of relationship. And I think that out of strong relationships, we can build stronger alliances and we can build a more secure world. These FTAs, sir, as we sit here, I believe are in Jersey's national, if I may use that term, interest. And I have no hesitation in recommending to members these principles for inclusion in future FTAs and a return to the Assembly should we be seeking to have other chapters extended in the future, sir. And I ask members for their support. Thank you.
Thank you very much, Minister. I ask the greffier to place a voting link into the chat in the usual way. Open the voting and ask members to vote. Members have had the opportunity of casting their votes. Ask the greffier to close the voting. The proposition has been adopted, 35 votes pour, no votes contre, no abstention in the link, and a further 8 votes pour in the chat. Very well. We now come to provision of affordable housing guidance, P96, lodged by Senator Mezek. Senator, do you wish for this to be read as amended by your own amendment?
No, sir, I wouldn't like that to be the case because I'd prefer for the Assembly to have the choice of what the ultimate debate is on.
Thank you very much, Senator, in which case I ask the greffier to read the proposition in its original form.
The states are asked to decide whether they are of opinion to request the Council of Ministers to withdraw the guidance on affordable housing which has been provided to the States of Jersey Development Company as found in the reports Housing Policy Guidance, Housing Affordability and the South Hill Development R139 of 2021 and Action on Housing, Recent Progress and Waterfront Guidance R157 of 2021 and to issue new guidance which stipulates a minimum provision of affordable housing at no less than 30% of the homes built in the proposed developments on the waterfront and South Hill.
Yes, Senator.
Thank you, sir. And if I could just start by saying that this will be a relatively long introduction to this proposition because I think there's quite a bit that needs to be said on this. But with this proposition, sir, I'm asking the States of Jersey to require the government to do better. I'm asking members to scrap the paltry proposal to deliver a measly 15% of homes as affordable in the upcoming developments on South Hill and the waterfront, and instead focus greater efforts to deliver the homes that people in Jersey actually need and can afford. And I ask for this because the housing situation is dire and it appears that there's no end in sight. In question time on Tuesday, the Chief Minister stated that Jersey does not have a housing crisis, but merely a housing problem. And he was echoing the words of his Treasury Minister there. So out in the real world, where the people we represent live, these comments have been met with a derisory response, whether in the column pages of the JEP, on social media, or just ordinary people chatting down the pub. You will struggle to find anyone in Jersey that doesn't think the Chief Minister and Treasury Minister called it spectacularly wrong with those ill-judged comments. And they were ill-judged because they are completely at odds with the lived experience of so many people, whether it's those in social housing who face rental stress, those in the open market who face insecurity and unaffordability, or those who save and save but cannot find a home to purchase. And not even those, sir, but indirectly, the comfortably housed who have compassion for others think that that perspective is out of touch, because there are many parents and even grandparents in the island who got their homes back when they were affordable, but who now face the prospect of losing their family members to this crisis as their kids and grandkids choose to move elsewhere for a better life. And all of this is compounding itself into a crisis which is now branching out into other areas of island life. Barely a week goes by now without a business leader speaking out about the struggles they face in recruiting workers, which they cite as being directly connected to the housing crisis. They either can't afford to pay wages to staff that would meet their rent bills, or more skilled workers are realising that they could have a better quality of life elsewhere, and so they're not sticking around. So we're all paying the price for this crisis in one way or another. And in this crisis, our government is using publicly owned land and a publicly owned developer to build homes which don't match the profile of the homes we most desperately need, and which in any event could be provided by the private sector if there is such demand for them. I think that that's an inappropriate use of our resources, both on principle, but also based on the numbers. So as things stand, we're to get only 173 homes out of the 1,153 proposed, which will be affordable, just 15%. Or to put it another way, sir, 85% will be unaffordable. Our government, using publicly owned land and a publicly owned developer, will be using its resources to make homes of which 85% of them are unaffordable. So the government have called this wrong, and they should be sent back to come up with something better. And their response, though, is that better isn't possible. This is as good as it gets. But they're wrong. The government has provided a response in their comments, which, while on the face of it appears credible and will no doubt have served its purpose and swayed some members, but every argument advanced in it is flawed, and so I'm going to go through each of them. One of the arguments they make is that there's housing need across lots of different tenures in Jersey, and not providing the right supply of open market homes would also cause problems. Well, the first problem with that, sir, is that they are overstating the need for open market homes because of their flawed reading of the Objective Assessment of Housing Need report. They say in it, and if members have access to a laptop or iPad to look at the OAHN, I recommend they do, but I can send figures around if members would like to see them. They say that because the OAHN report says that there's a need for around 900 new social rental homes over the next 10 years, and the Island Plan is projecting 1,500 affordable homes, then that means that they're exceeding the demand. But that's wrong, and it's wrong for two reasons. Firstly, the OAHN report in their numbers for projected owner-occupier need don't distinguish between what's the need for assisted purchase and unassisted purchase. So affordable versus open market in the owner-occupier sector, the OAHN doesn't distinguish between. But we know that there are around 1,400 applications for assisted purchase on the Housing Gateway right now. So when you include these two types of affordable tenure together, the social rental and the assisted purchase, the Island Plan projections do not meet that need, and in fact, sir, they fall short very considerably. The second problem with the OAHN figures is that their projections for social rental need and private rental need were based on the current eligibility criteria for the Housing Gateway, and those current criteria have already been judged to be inadequate by the government, who have stated that it's their intention to widen that criteria, and they're absolutely right to do that, and I completely support them in that. But the OAHN report itself says that if the criteria for social housing was to be expanded, then their numbers would need to be updated. So the effect of this is that in the OAHN numbers, which the government says it's working from, the need for affordable housing is understated and the need for open market housing is overstated. In fact, many of the households that would have been put in the open market rental housing need are people who are only in that category because they're legally not allowed to apply for social housing. But if they were legally allowed to, that would be where the need would be. So those numbers are not being used appropriately by the government and by the SOJDC to work out the housing need over the next few years. The government says that in arguing against this proposition, that they're seeking to add a supply of a mix of housing tenures, and that reducing that supply would also create problems with the housing market. So not producing these open market homes would still cause problems in the housing market. It would just be in another part of it. Also, in response to that, I think you could reasonably argue that on principle, it's the private sector that's the place to be delivering open market housing, not the government. But forgetting the principle for a moment and just looking at the numbers provided in the draft Ireland plan, I really think it is hard to think that supporting this proposition for the homes to be provided in these two specific sites for affordable housing rather than open market housing, it is hard to conclude that that's genuinely going to cause problems in other parts of the market when you look at the numbers. So looking at those numbers, on page 186 of the draft Bridging Ireland plan is table H1. That table, which admittedly is a few months out of date now, but it is the most up-to-date reference we have to use now. Those numbers show that the homes being delivered right now as we speak, so the homes which are currently being developed or which have planning permission to start whenever, right now, over twice as many open market homes are being developed than affordable homes, which raises the question, why would the government be using its resources to add to the housing supply, which is overstated by the OAHN and which the private sector is already getting on with delivering twice as much of, than the housing supply which the OAHN understates the need for and which the private sector is contributing precisely zero for. And I urge members to look at that table H1 in the draft Bridging Ireland plan on the private sites in town and the windfall out of town. The number of affordable homes to be provided by the private sector is precisely zero, none. So, sir, in taking these publicly owned sites on South Hill and the waterfront, the government is planning on bolstering the wrong numbers. They're planning on bolstering the supply in the areas that right now the plan is most successfully catering for, and they're not providing enough for the part where the plan is least successfully catering for. So that's the first argument I think they've advanced, which is flawed. The next argument they're advancing against this proposition is the money, and they've produced a financial assessment from Dow, Schofield, Watts, which shows that this proposition is simply impossible. And well, that's me done. Hook, line and sinker, surely. But no, sir, This financial assessment is itself completely flawed. And if I may say so, it was destined to be flawed and destined to demonstrate a failure because it was set up precisely to do exactly that by setting the benchmarks for that analysis to be done by so that it would inevitably reach this conclusion. So rather than ask for a financial assessment to be done to find out how this proposal could be made possible, they set it at the outset to find a way of showing it wouldn't be possible. So surprise, surprise, that's eventually what it concludes. And it did that by setting specific benchmarks, and those are benchmarks which didn't have to be set in the first place and where there were alternatives, but that they just couldn't be bothered to examine instead. So let's look at those benchmarks. The first is that their calculations presented in that financial assessment are done on the basis of the current plans remaining exactly as they are, but just assuming that the SOJDC doesn't get to realise the entire value of a greater number of properties in there. The plan's the same, but just taking in less money from those plans, which completely ignores the fact that it is in our gift to change those plans if we want. If viability could be improved with an alteration to those plans, that was not considered in this financial assessment. The second is that they've done these figures by determining that the shared equity percentage held back by the SOJDC would be 30%. And I ask, why? Why 30%? Why is that number the one that's picked for that? You could set it at a lower amount if you wanted to help make things more viable. And I point out that even Andium doesn't offer 30% in their home buy product. They actually only offer 25%. So they've deliberately set this to be more generous than other affordable housing options, which inevitably has the effect of making the numbers look worse. And they didn't have to do that. And that's partly why the financial assessment is flawed. The third one, and possibly the one I'm prepared to give the most ground on, but the figures do take into account the SOJDC paying back the price of the land. And you could argue that selling the land or requiring the SOJ to pay back for the land at a sub-market value could be justified on the basis that they're serving a social purpose as well, rather than making them pay full value for it. I'm not suggesting that that's definitely the right thing to do, but it's an option, and it's an option that wasn't considered in this. So I think that those three failures show that the government did not consider a wider range of options to make this viable. So the numbers that they presented are just not credible. And this headline figure that they may seek to use of this proposition leading to a £66 million loss is just fantasy. It's not real. It's based on hypothecations. And if I could quote the Constable of St Saviour, who I think put it really well in a debate yesterday on the taxation of cannabis manufacturers and what the effect would be of not receiving projected income from them. She said, you can't miss something you never had. And she's so right. I put it in these terms, where to say that adopting this proposition would lead to a £66 million loss is as credible as me claiming that last week I lost £100 million. I lost £100 million because I didn't win the Euro Millions. Of course, sir, that's ridiculous. You can't miss something that you never had. So the benchmarks they set were deliberately to reach this conclusion of failure. The last argument I want to address that the government has advanced against this proposition is that it says that having to relook at all of this would risk causing delays in these projects and therefore delay providing any supply here. And the delay of providing any supply would be a bad thing, irrespective of whether it's open market or affordable.
So the first thing I want to do in addressing that argument is refer members back to what I pointed out in the draft Bridging Island plan projections for the delivery of open market housing. There's already plenty coming on board at the moment, so it's not a dramatic loss that we can say will have a harmful effect on the wider part of the market. A loss in the affordable sector has a much greater impact. But would adopting this proposition really cause a delay? Well, when it comes to the waterfront part, that's not credible at all. The waterfront project is years away. There are years before that project starts going ahead, and there is plenty of time for them to alter the plans to make them feasible. They are not standing by ready with spades to put in the ground, like Andiam was with the Ann Court development when this government tried to delay that. And with South Hill, it's not particularly credible either, because they already have a planning application in and they have the ability to alter it if necessary. The government clearly does have room for manoeuvre to change the financial arrangement on it, which could get the financing to deliver the scheme and still leave enough profit for the as yet undefined affordable housing scheme, which is proposed in the upcoming government plan. And anyway, sir, either development could be delayed anyway. All it takes is for planning to decide that they oppose parts of the detail in their application, and then they have to go back and alter it. So delays should be built into these processes, because they can happen at any point and for any reason. So that's what I believe is the main case for providing affordable housing in these publicly owned sites by our publicly owned developer. I think the numbers demonstrate that there is greater need in that sector than there is the open market, where there is already work being done to provide a much greater supply at that level. And the numbers at which they're basing their assessment of need there are flawed, and they're flawed by admission in the terms of the OAHM report itself. But given the context of the recent debates that there have been about the housing crisis in Jersey, and in particular with this proposition on the horizon, which I've made an issue now for round about the last year with my previous propositions on this as well, and the comments that have been made in the media recently by members of government saying that there is no housing crisis, and the backlash that those comments have provoked, I made a commitment to my constituents that I would use this debate to give them a voice. And in the run up to this debate, I asked for islanders to get in touch with me and tell me about their experiences with housing, so together we can really highlight how important this issue is and show what human impact it's having. And I was absolutely inundated with responses from people pouring their hearts out to me, and it would take hours to read out every word that was sent to me. But I am going to read what I think are the most powerful accounts that I've been sent. And I make no apologies for taking some time to do this, because I think it is important that the voices of the people we represent are heard by the decision makers in Jersey. So what I'm about to read is what real people are saying and what they really think. And it's heartbreaking hearing from those who have totally lost hope, but also understand, also so we can understand the impact this is having on our wider community. And a lot of the people who got in touch with me were actually key workers, sir. I had somebody get in touch who's just about to qualify as a social worker, a role which this island is desperately in need of. And she said, "I've grown up here and my dream was to support the people I've grown up alongside and who needs someone who shows this island and who knows this island and its services inside out. My other dream is to own my own home so I can give my daughter the life she deserves. No matter how hard I work, once qualified, I will never be able to save money as well as pay rent and buy the essentials, never mind buy a house here and give my daughter all the things my parents were able to give to me. I'm considering now leaving my home, my island and the people that I love, so I can afford to live comfortably without the extortionate rent and the constant struggle to make ends meet. I will also have a real opportunity to buy my own home. How incredibly sad it is that so many of us will have to leave our own home, our island, because we can't afford to buy one or even rent one without starving, freezing, or both. So that's a homegrown social worker that we'll be losing out on. I heard from a young healthcare assistant who's already left the island. He said, I was a healthcare assistant earning about £1,700 a month. My rent was increased from £895 to £995, and the tax department decided to increase my rate to 20%, which would have left me about £300 to survive a month. So I left Jersey and joined the army. One of the best decisions, and I wish I'd done it sooner. I'd love to live in Jersey again one day, but it feels impossible considering the prices of flats to buy. So that's a healthcare assistant we've lost. I heard from a couple who are both teachers who are planning to leave. They said, we feel forced out of our home as we cannot work out a way to be able to afford a family home or even rent a family home, even though we're both full-time secondary school teachers who feel as though we earn a good wage. Once we factor in either taking time out for childcare or the cost of nursery, we will struggle financially with high rents, the inability to save for a deposit due to these rents, and the extortionate housing prices that will leave us with high repayments. We are deeply saddened to have to leave a place we love and where we've built a life, but feel as though we have no choice if we wish to have a family. These considerations are only for one child. We couldn't even begin to think of having more than one child here. So those are teachers, again, key workers who we're leaving. But some people got in touch because of the experience they've had with bad landlords. In fact, sir, those are exactly the types that we were meant to be catching by the landlord licensing scheme, which was proposed earlier this year, but which the states threw out. I heard from one single mother who was messed about by a previous landlord who was inappropriately issuing them notice to leave the home. And she said, given my experience, it's an insult to hear certain ministers downplaying the situation by calling it a challenge rather than a crisis. When a Jersey-born individual working full-time and earning a decent salary faces homelessness and is unable to find affordable housing for herself and her child after 9 months of actively looking, only to eventually secure a home at a 54% increase, there's no other word aside from crisis that does the situation justice. Many islanders regularly argue that the affordable housing offered by the states is never truly affordable to most couples when average salaries and the high cost of living are taken into account. Single parents have even less chance. Please do consider offering further support to single income families with children when determining whether housing is affordable in your proposed solutions. I heard from a young islander who was threatened multiple times with an illegal eviction and had to fight much harder than she should have to get him to back off and just obey the law. And she did eventually find a place to move to and said, I now have found accommodation, albeit £1,400 per calendar month for a 1-bedroom, but I know for certain I will not be buying property here. With my high rent, I can't save for a deposit for a mortgage, especially a deposit for property prices here in Jersey. I'm planning to save up enough to move off island on a permanent basis. There's not a lot to offer young adults here, and the property market is the final nail in the coffin. So that's another young Jersey person that we will be losing. And most of these people who got in touch with me were young. One said, I'm about to be 25, working in finance, and I currently live with my mother in social housing because I can't afford to pay £900 plus rent for a flat. It's beyond irritating when I game online with friends around the world who are barely 21, who can afford to go live by themselves and still have a good quality of life. Over here, the decision is, well, I'll never be able to buy because the housing market goes up by my annual salary every quarter, so I will never be able to catch up and so have no choice than to rent. However, if I do rent, then I can't afford to actually live. It's gotten to the point where I'm going to finish my exams at work and I will have no choice other than to move abroad. I'd love nothing more than to stay here where I was born, as it's a great place to raise kids, it's safe, and I do love living here, but I see no actual quality of life here. And another young Jersey couple who left Jersey just 2 months ago. They said it was driven by the fact that we would have been saving for many more years until we could afford to buy anywhere. Even though we both earned good wages, I do think we would love to come back to Jersey, and I have many family members who feel the same. But with the current housing crisis, it's incredibly unlikely that we'll ever be able to do so. And it makes me so sad because I really do love Jersey and would love to come back one day. However, if developers keep building luxury apartments, not only will I not be able to afford to come back, I won't want to. But the hardest ones to read that I had from people, some of whom were my age, and I had from one person who actually went to the same school as me, who her and her partner are on a salary of, or on a combined income of around £70,000, and they even managed to get about £100,000 saved. But whenever they try and buy somewhere, they just keep getting outbid. They say every day that we do not become homeowners, the prices spiral further and further out of reach. I'm angry. I've done everything I was told to do, work hard at school, get a university degree, get a good job, and yet this next stage in life is being denied to us. I feel failed by the government of Jersey and currently feel ashamed to call myself a Jersey resident. This is not just affecting the lowest earners. I can't even begin to imagine how those trying to survive on a single income or minimum wages are coping with this insane crisis, but also middle earners who can't seem to get a foot up because the goalposts keep moving at such a considerable rate. When will we receive honest security that all citizens deserve from our government? And a young professional who lives in St Saviour said, "I'm in a complete state of overwhelm. I decided to go into full-time employment 5 years ago at the age of 18 and work my way up. I'm now a qualified project manager. I never had a stable home as a child. I have experienced homelessness before. I now am very proud of how far I've progressed and now have a salary where a mortgage provider could consider me, but unfortunately I'm outpriced by the market. I've always lived in fear of being kicked out and have wished for a forever home to call mine. I just don't know if that will ever be possible here in Jersey." And so lastly, the one that I found the most heartbreaking to read, again from somebody my age, who said, "I've lived here my whole life. I love Jersey. In fact, I hate how much I love Jersey because for a long time now, I've worried about how I would ever have a future here. It hurts knowing that my options are pay an insane amount of money for a one-bedroom flat and stay on the island I love with the people I love, or move to the UK, take the same money and buy a 4-bedroom house, but be miserable and alone. This isn't a fair choice, but I'm one of the lucky ones who has the help from a parent who worked hard their whole life. Still though, I've been looking for my first home for about 6 months now, and even with the same amount in a deposit as what the bank will lend me in a mortgage, it's been nothing short of a nightmare. During the time I've been looking, I've been watching the prices rise and rise, and so too the feeling of terror, knowing that I don't really have time to find the right place I'll be happy in, because by the time I've done that and fought to secure the property over from everyone currently buying investment properties, I'll be unable to afford even a 1-bedroom flat, and then there is no hope left. It makes me sad that this is how our government choose to run this island, driven by greed and ignoring the people that make this island what it is. I truly worry what Jersey will look like in 10 years if nothing is done." And so that's actually a relatively small amount of the correspondence I received in the run-up to this debate. Those people know that there is a housing crisis, and they have no confidence out there that this is being resolved. The language used by the leaders of our government matters. And this proposition matters because it seeks to take a more appropriate approach based on the numbers, based on a better understanding of what those numbers actually mean, and recognise that a publicly owned site built on by a publicly owned developer could and should be used to provide some of the housing need which is most desperate. And the government attempts to demonstrate why this isn't possible are flawed to their core, because of the benchmarks they set up to make sure they were flawed. And if we had leadership that recognised that there was a crisis and listened to the voice of the people who have spoken out about this, then they would take a different approach. And that's why I'm asking the States Assembly to say to the government, you can do better than this, so please go away and do better than this. The arguments about delaying housing supply are not credible. The arguments that this would cause greater problems in other parts of the housing market are not credible. But the very last point I wish to make, sir, on this before making the proposition is that early next year we will be looking at a Bridging Island Plan debate where many people are extremely worried about the changes to the character of our island that we may be facing with the loss of green fields. And with the amendments that have been lodged to the island plan, which take out some of those proposed sites for rezoning for affordable housing, to make up for that loss, the Environment Minister is then proposing a plan B of sites, which many members are also equally worried about. If we don't lose those green fields and don't provide adequate supply of affordable housing elsewhere, we will be failing our island. And if we can't meet that demand for affordable housing in town sites, then it is an inevitability that greenfield sites will be looked at instead. And so I say to those members who are concerned about our countryside and concerned about green sites, you can't have it both ways. If we want to make sure that we adequately house Jersey people, then we've got to build the homes for them. And that means taking every opportunity we have and not taking great opportunities with land we own and can use for free, with a developer that we own, to provide a profile of homes for which there is no demonstrable great need for, and which, if there is a need, the private sector can deliver it instead. Our job is to do better than that. And so on that basis, I make the proposition and ask members to increase the proportion of affordable homes destined to be on those two sites in St Helier. Thank you, sir.
Is the proposition seconded?
Yes, sir.
There is an amendment. I'll ask the greffier to read the amendment.
Page 2, paragraph, after the words at no less than, for the words 30%, substitute 50%.
Senator Bezic.
Thank you, sir. Members will be pleased that my speech for this amendment will be extremely short, because the purpose of this amendment, sir, is to offer the States Assembly a choice as to what our target should be for these two sites. And I make no apologies for saying that I think every home that the government is responsible for delivering directly should be an affordable home that matches the profile of need that there is for affordable housing up there in the island. I don't think it's our job to be getting involved in providing the profile of homes that ought to be delivered by the private sector. But I accept that work has been done on these projects already. I accept that they are sites of very special interest for the island, especially the waterfront, which is a gateway into our town and has the prospects of being transformative for town in a positive way, and which I want to see. And so I think that there is room for a debate on what the proportion is, what we are prepared to settle for. I want that proportion to be as great as possible. And I originally, when I first brought a proposition on this, I pushed for 50%, and I stick with that. I think that is what we should go for. But in accepting that some states members may have different views on, I present a choice for them. If they vote for this amendment, then we can go for 50%. But if they think that actually that's too ambitious and we should scale that back a bit, then 30% serves as a compromise, and members can vote against this amendment and then proceed on that basis in the main amendment. So I ask for 50%, but say to members, we have a choice here, and 30% would be a good compromise if members wanted to seek that instead. So I propose the amendment.
Is the amendment seconded?
Yes, sir.
I therefore open the debate on the amendment. Conor Tarbison John.
Thank you, sir. We all received correspondence from a former States member in recent days asking us why we're not looking at 100%. So we're seeing local people leave the island, local people with long established roots in Jersey leaving on a weekly basis. We're seeing professionals who come to the island to work in health and education, cashing in on their properties and returning to the UK, using the windfall from the increase in value as a bonus pot pension. Businesses are finding it harder to recruit people because there is such a shortage of affordable properties. We all need to do more to find solutions. As Senator Mezek states in his opening, government-owned land developed by a government-owned company, surely we don't have a better opportunity to provide what the island needs. Last time we debated South Hill, I spoke about the opportunity to use the site for essential employees. If we housed the essential employees in shared equity properties, they would remain affordable and could be used in perpetuity for people that we need in our key services. What price or value do we put on having sufficient health and educational professionals? Key workers who are vital for us to provide the services that are so urgently needed. They need homes that they can call their own. Of course, we don't only need key workers. Who remembers those essential employees who helped us through the pandemic? Not that just those who work tirelessly in the health and care sector, those involved in retail, security, the supply chain, logistics staff, postmen and postwomen. How do we expect them to buy their first home on the open market? Senator Mezek referred to the report that we've all been given. It states the expected return a developer could expect was between 15 and 25%, and the SOJDC expect to get 15%. Of course, financial considerations are important, but let's not forget that only a few weeks ago, this Assembly turned down the opportunity to save £254 million. Yes, £254 million. Those speaking about the importance of raising funds today should reflect on that. Reflect on the fact that if you don't spend more than you need to, then you don't need to raise more than you need. This week, we've heard the worst kept secrets about Lekenove and St Saviour being released for housing. I can tell you, sir, that these two sites aren't the answer on their own. They are very welcome, but we need to utilise government-owned land wherever we can to provide the solutions. Value is not just about pound signs. Value is about people, families, Jersey families, families of key workers who could become Jersey families. And I believe we have a duty to those people and future generations to provide the solution. Thank you, sir.
Very much, Conor. Deputy Young.
Thank you, sir. Senator Mezek and I agree on a very great deal in this situation. And I'm going to start by absolutely saying, I believe we have got a crisis in housing. It's critical. I read reports recently that 2/3 of our young people in the island were either thinking about leaving the island or had already made arrangements to do so. And that situation is desperate. It's probably a matter that is being discussed around every family Sunday dinner table, I expect. What are we going to do about our children and our grandchildren and their future? How can they? Oh, what about youngsters who are living outside the island, who have Jersey residents who have had aspirations to come back to Jersey? What they see is the door being closed to them to come back because of the housing market and what we've allowed to do, what we've done collectively. I believe we've failed our young people. And I'm grateful for Senator Mezek reading those accounts I think we could have all cited many, many more. In my own family, that situation also exists as well for young members of it. And one will do our best to help them. But the bank of mum and dad doesn't always, it's not the solution. Now, I want to deal with the proposition of Senator Mesic because I think it's a vital, important one from the point of view of planning law and planning powers and the island plan. And I was grateful for the senator's last point that he made in his proposition, that we have the draft island plan going through its consultation stages. With the planning inquiry current, I listened to the debate. It wasn't a debate; it was a hearing at the planning inquiry about all the views. And of course, it is absolutely right that the zoning proposals that I've put forward for zoning of privately owned land in the island plan for affordable homes, it is right that those are challenged. Those are challenged by both states members and challenged by many members of the public. When I took on this role of Environment Minister, I don't think housing prices were anything like they are now. But I certainly did not want to see any zoning of greenfields at all. But we have protecting the countryside and our coast is vital, but people have to live. We have to, our community has those, nothing could be more fundamental than housing needs. So with the greatest reluctance, the island plan proposes some zoning of privately owned sites in the countryside, and I tried to make those as the least damaging that I could, to achieve that they were as sustainable as possible. In other words, they didn't have adverse effect across the whole island in the wider context of infrastructure, roads, transport, schools, everything. But nonetheless, there are other members have put forward other proposals that will have to come together after the planning inquiry, and there will be that debate in March after the inspector's report, and I will have the inevitable job of recommending to the states which of those I present to you the final analysis, which of those fields, because it will be your decision, it will be members' decisions and not mine. So I'm going to say one other thing here. I absolutely distance myself, and I have done to my colleague ministers, with the financial arguments. This is not about money. It's about people and homes. Now, I personally, I'm not a member of the Regeneration Steering Group who sets policies for state-owned land, and I've made it claim that I certainly don't subscribe to the argument that says a gain that you anticipate you might make in the future that you don't make is a loss. It is not. As Senator Mesic spoke about, well, I could have won the lottery last week. I could have sold, if I still had a house that I sold a number of years ago, it would be probably worth several £1 million more now. Well, I haven't. That's the reality of life. So when one looked at those numbers that are in those comments, the astonishing thing to me is they don't deal with the period 21 to 25, which is the island plan period, that all of the numbers that Senator Mesic spoke about. He quoted the table on page 168 of the draft island plan, I think. Those are based on the 5-year supply, 2021 to 25. The sites, the loss or the anticipated loss is in respect of a scheme that actually is not actually a scheme at the moment. It is a vision, a framework vision that the state's SOJDC have for the future development, and it's a very bold vision, and I admire it very much. But the point is that it is for the second period. It is for 2026 to 2031. So I really struggle with a financial set of figures that says we can't do this now, we can't make an adjustment now, because of what might happen in 5-6 years' time, or anything up to 10 years' time. There are 101 financial variables which may change. And one of those things is what we call affordable. Where we know that what has happened in the past in Jersey, previous planning ministers, environment committees over donkey's years have zoned greenfield land for affordable homes, and they've done that using legal powers, because the law gives the states the power to say, we zone that piece of land for affordable homes, and it can only be used for affordable. And that's the proposal in the current Island Plan, to maintain that. Those greenfield sites can only be used for 100% affordable homes. But where the problem comes is what is affordable. And of course, the reality is that over the decades, all of the houses zoned as being affordable, guess what? Have all become non-affordable. And so we haven't had those mechanisms. And so past members have struggled over many, many years to try and define that. Now, and I think that is one of the central issues in planning policy that we have to bottom out. And I'm going to invite, I'm hoping that the Housing Minister speaks in this debate, because it's really important. Because Senator Mesick's proposition addresses the current requirement, or what's being proposed by the Regeneration Steering Group, my colleague ministers, at 15% equity share. Not affordable homes, equity share. And as I understand it, that equity share means that people buy and they pay only a reduced price, and that the balance of the value is not paid by the person, that is held somewhere, probably as a balance sheet value within the SOJDC, I would guess. But it also says, well, I also understand that there is a 35% of houses being sold for first-time buyers. Now, what does it mean, first-time buyers? First-time buyers used to mean, in fact, they still do under the current Island Plan, those houses that are provided for those that cannot access through reason of the normal housing market. That's what the law says. So I'm going to hope we get some clarity on that, because I begin to think we probably I certainly think we may have got ourselves in a bit of a pickle here about the definition of affordable homes. We need affordable homes. As far as I'm concerned, we need more. I don't mind how we make those homes affordable, the various devices we use. You know, so shared equity is great. We could get more of them, that'd be good. If not, deferred purchase. For example, years ago, we used to have a thing in Jersey called the supplementary loan scheme. That meant that people got loans from the states to buy houses that they couldn't afford to pay back. And there, many families in Jersey benefited from such arrangement. It was visionary. And so what happened is that people had those loans. They only paid back the proportion of the loan that they could afford, their income allowed. And as over the years their income rose, then they would then pay more, and eventually pay the whole amount would be dealt with over many years, sometimes over 30, 35 years. And that was an excellent arrangement. That's all gone. Now that's, to me, a perfectly good example of how you can have an affordable housing arrangement, but it has to be underwritten by the states in funding in some way. I mean, we're borrowing millions of pounds on other things. I really don't see why we can't underpin it into housing for young people. So I think there are lots of ways of addressing affordable homes. Now, and of course, I struggle to think, well, can I vote for the proposition? And it really gives me a problem, because first of all, the South Hill part. It affects South Hill, and unfortunately, I think the problem, you know, I think we probably messed up in South Hill. It's gone too far. We've got a planning application. The supplementary planning guidance that I wrote, or I issued probably at least 2 years ago, is there. And so to backtrack on it now at this stage, I think would be a potential problem. And of course, South Hill is, I believe, one of the sites in the short term. And of course, it would generate money that would go into other housing sites, straight into Andium's funds, I expect. So we get more housing sites. And so I think that does give me a procedural problem. But on the other part, the waterfront, I'm very much in favour of Senator Messick's proposition. He has an amendment. He has an amendment. Senator Messick has got an amendment to the Island Plan, Amendment 41, which I've made comments on to the planning inspector and asked him to look at it. The Amendment 41 says that basically that there should be a universal requirement that all state-owned sites should be, as I think the Conitile of St John said, 100%. 100%. Now, what my answer is that I think we need to be more site-specific, and I worry in the past about having blanket directions, because the circumstances on individual cases will vary and affect their viability. So the amendment, sir, I mean, obviously we're on the amendment to the amendment, but I'm taking advantage of the opportunity. I effectively think twice in this debate. I thought I'd do it early, setting out some planning principles.
Well, actually there's only the one amendment. So it's not an amendment to the amendment. There's just the one amendment, and that's Senator Messick's amendment, taking it from 30% to 50%.
Right.
That's what we're discussing.
Thank you for clarifying that, sir.
Yeah.
But anyway, Senator Messick also says that if we go with the proposition, this won't eliminate the need for zonings of green fields and I think there is an issue that members need to think about in this debate. There is a need also for family homes, 3-bedroom houses, and for the greatest will in the world, it's inevitable that the developments in town are going to be apartments and flats. They're going to be decent ones because planning standards are going to increase. That's part of the Island Plan policies, that we do better in those developments. We get more living space, we get more amenity areas, and all those sort of things. All those are in the Island Plan policy. But we will need some family homes. And secondly, we have the need that we cannot discount. In fact, it's really important. We need to ensure that going forward, those rural communities throughout the island have some breathing space to have some additional, to allow them their demographics to change, to bring in more younger people into those communities, to enable them more to stay in as viable settlements. And then there's the opportunity to right size. Either that means people who are occupying family homes that are underoccupied, severely underoccupied, having the opportunity to release those family homes and go into right size units. My personal view is that I don't expect that people will want to go from living in the middle of in the countryside, in rural communities where they've spent their lives, suddenly to go live at an apartment in town. I don't think they're likely to do that. So I think those things there, I think those needs will still exist, notwithstanding the definite need to do more for affordable homes on state-owned sites. More. Now, what is that proportion? I do remember, in a previous life, I was responsible for advancing the original waterfront plan in the early 90s, when the states were reclaiming the West of Albert area and La Colette, and the states agonised over whether or not the waterfront area was, whether there was any homes in it at all. The debate was, well, shall we have open green fields? Can we use it for all sorts of other things? Or shall we have it as subject for homes? And eventually it was resolved by decisions of the first housing development that ran, was divided up 50-50 between affordable homes, in that case they were for social rented, and for open market home with first time buyer conditions. And that development has been very, very successful. And I know that those first time buyer units in that unit are probably one of the most sought after developments in the waterfront area. So that indicates what was in states members' minds, 50-50. And I don't think it was not, yes, we wanted all the other things. We wanted all the other good things, public realm, amenities. But my personal view, at some point, the states would have to put their hands in their pockets and provide some funding stream for the infrastructure that we need. And of course, I do remember our previous former chief executive proposing to us that we have an investment fund, some kind of investment fund, possibly even by public subscription of a public bond to invest in those monies. And that's the sort of creativity that I wanted to see. You know, people get 0.1% of an interest at the bank. Why shouldn't people have a share in the infrastructure, the waterfront, and the community facilities to go with it? Rather than say, no, we can't have any affordable housing because we've got to then make sure we get enough money to pay for these other things, because we're not prepared to look at those alternative means of funding. Bearing in mind, we're five years away, 5 to 10 years away from that. So I think where I've got a real problem is how I vote on this, because I'm really stuck, and I think I've missed the boat on intervening here. I think I've missed the boat on South Hill, because it's too late, although I could still call in that planning application now for a planning inquiry and have this issue thrashed out in the planning inquiry. I have chosen not to do that at the moment. It's also possible that the planning committee, if I don't call it in, they've decided they can decide to use planning obligation agreement powers to require as much social housing and much affordable housing on that site as they can. So it's not done and dusted. But for me personally, it's late. But all is not lost on the waterfront generally, because I certainly, when that scheme comes forward, it is my intention, and I've announced it and I'll repeat it again, to call it into a planning inquiry. And that planning inquiry will look at all the aspects, including the use of that land for affordable homes, and look at all the other ingredients and so on of it. And so I really cannot give any credence to these viability assessments against a scheme that doesn't exist and hasn't been subjected to that planning process. So all is not lost there. And also, there is the opportunity, Senator Mezzik, for your amendments. Amendment 41, which is before the planning inspector on this very, very subject across all state-owned sites, where, of course, when states sell land, we can put what conditions on it we like. But when it's private land, you can't. You have to use the zoning powers. But government land, we can do what we like. And of course, years ago, what used to happen, government acquired all the private sites, and then, of course, it could put what conditions on it they like, because it bought them. Now, that at the moment is not the current policy, but there are ways of doing it. So all is not lost. There are things that can be done on Amendment 41 from after the report comes from the planning inspector into the debate here next March. So I think at the moment, I find it really difficult to vote against these propositions. The current island plan policy is very clear. States-owned land, which is developed for residential development, affordable homes should be given precedence. That's what the current island plan says. That's a 2011 island plan revised in 2014. It's a clear principle. And to me, I have a real problem as an environment minister with that island plan policy that I have responsibility in law for saying I don't support a proposition to increase proportion of affordable homes. But I do want flexibility On what percentage goes, I prefer it to be on a site-by-site basis, as I told the inspector, to allowing for individual variations. So, sir, I hope that helps other members in what they might do and say in here, but I wanted to put those matters on record, and then after the debate, I'll then decide what I then do on the propositions. But, you know, Southfield is a problem for me. On the waterfront side, it doesn't have that problem, but unfortunately, we're presented it with a package, and I wish I'd have brought an amendment. I didn't. I missed the vote on that, so I'm going to have to take it as it is. Thank you, sir.
Thank you very much, Deputy. Deputy Pinnell, on the amendment.
Thank you, sir. I would like to begin by reminding members of the wording within Senator Mezek's original propositions relating to the waterfront and South Hill developments. The Assembly agreed the Council of Ministers amendment to P165 on the waterfront, which required the Council to issue guidance to SOJDC with a view to maximising affordable units and a range of other residential accommodation, while, and I quote, maintaining the overall viability of the scheme, including all public realm improvements and other community and leisure uses. P69 on South Hill contains similar language, guidance to be issued to maximise affordable purchase while maintaining the overall viability of the scheme. Members will be aware that a third party was commissioned to review the financial impacts of including shared equity housing on both developments. So the conclusions of that review are unequivocal. Anything more than 15% on each site will jeopardise the viability of the schemes and create unacceptable risk levels within the developments. These are the conclusions of the independent reviewer, and no amount of revisiting the work and dedicating more time will change these fundamentals. In fact, the independent reviewer has helpfully costed the impact of moving firstly to 50%, 66.1 million. That's the cost of introducing 50% affordable purchase. The cost being the difference between 15% shared equity and the 50% shared equity. Overall, taking both developments together, incorporating 50% shared equity will result in a cash loss of £32.5 million. Further, members will be aware SOJDC is required by the provisions of P73 2010, approved by the Assembly, to self-finance developments. Lenders require a reasonable return before they will support a development. Members should draw, therefore, the natural conclusion that no lender is going to finance developments that are loss-making from the outset. If the Assembly votes in favour of this amendment, the Board of SOJDC will have no option other than to go back to the drawing board on both developments. There will be an indefinite delay, and it's no exaggeration that the developments may never happen. I don't say this lightly, but again, I go back to the conclusions of the independent review. It will create unacceptable risk levels within the developments. Why? Because it comes back to the inconvenient truth. These developments have to be viable. Viability in terms of making returns and being able to be supported by lenders. Sir, I think I can safely say that no member wants to delay the delivery of much needed further housing on both sites. A vote for 50% will do just that. For that reason, I urge members to reject this amendment. Thank you, sir.
Very much, Senator Ferguson.
Thank you, sir. Personally, I think SOJDC has outlived its usefulness, and I would give it an honourable burial. I'm not sure that their drive to provide lots of luxury flats and lots of office space on the waterfront is now, in this current climate, a valid business model. However, as I recall, the original plan for the waterfront site provided more homes and civic spaces rather than the current plans. It is time members recalled that land being developed by SOJDC was already in possession of the states. And I'm not totally convinced that the valuation which is used in the transfer from Jersey Property Holdings to SOJDC complies with the original procedures set out in the original proposition P73. The housing on the waterfront, which resulted from Senator Lamou's Housing Committee's competition, is attractive, well designed, and comprises social housing and free market, as mentioned by Deputy Young. This is the sort of project we need, not the soulless office blocks being put up on the waterfront project. The Les Sablons, Kennevet and Bellevue developments demonstrate the ability of the states to provide housing for low-income families as well as social housing. We just need to cater for lower-income families rather than allowing wealthy individuals to buy as many houses as they like, a change which was slipped through during the election period prior to the last election. The state, in its broadest sense, welcomes wealthy immigrants. They do provide a leaven to the community. However, too many, and we have developers building luxury housing and ignoring the affordable housing market. Mind you, the wealthy immigrants have offered assistance to the island during crises, but these offers were scorned, so we're losing both ways. We do not want to build mousetraps, which our largest independent developer specialises in. The flats that they're building, some of them called luxury flats, they have a kitchen in a corner of the living room. If you turn on the kettle, you can't hear the television. I mean, is this really a luxury setup? I don't think so. My apartment in New York, when I was a student, was a great deal more efficient, even if it was built in 1920. However, I would suggest that a competition a la Senator Lamou might provide more imaginative designs. And we do need now to concentrate on decent accommodation for low-income families and social provision. And in fact, I support the proposition as amended. Thank you, sir.
Thank you very much, Senator. Connie Tarbers, St Mary.
Thank you, sir. I didn't expect to be so quick. Affordable housing. The term affordable housing is a farce. Most first-time buyers cannot afford a presently termed affordable home. Perhaps the term should be renamed budget housing, because affordable housing does not exist. We need to build 2 homes for the price of 1 currently affordable home for the term affordable housing to ring true. It can be done, and we need to change our method of build in order to do so. And by that, I mean either flat pack or module.
Yes.
Built off island, as we don't have enough skilled tradespeople to build them here. If we don't do this, we will lose vital workers from within the island, and it will discourage much needed skilled people from coming here. People who we desperately need. Health workers, teachers, and tradespeople. There is a crisis. We need to address that now. We had a crisis 50 years ago. It has got worse over the years because we have not kept up with demand. Thank you, sir.
Thank you very much, Conor. Does any other member wish to speak on the amendment? Deputy Lavie.
Thank you, sir. And can I just start with the greatest of respect? One point from my colleague, the Planning and Environment Minister, about the Victoria and Albert Pier development. That is not a mixed use. That is what we call a dormitory. There's no public infrastructure, there's no amenities, there's no vibrancy, and we have to set our ambition higher for the rest of the waterfront development. But I'm very happy to respond to him and to his call to me to explain the situation as regards what's proposed on the waterfront. On SOJDC's residential projects to date, that's College Gardens and the Horizon development, we have 382 open market units that have been sold. Of these open market sales, 35% have been to first-time buyers with no discount or shared equity, but the vast majority of that 35% have taken advantage of SOJDC's deposit saving scheme. I'll explain a little bit more about that later on. On SOJDC's future developments, they fully anticipate a similar percentage of the open market units being sold to first-time buyers. They're being approached daily already by first-time buyers, and a waiting list has already started to be compiled. They're all directed to the waiting list and in constant then contact with the sales team. The addition of 15% shared equity units to support those that need more help getting their first step on the property ladder will mean that SOJDC are targeting 50% of the units on South Hill and the waterfront being sold to first-time buyers. 50%. This is so important so that we can capture those who are just over the cusp or on the cusp in terms of earnings and qualification for the home buy gateway products that Andean produce. The deposit scheme has proved very popular. It's a way for first-time buyers to effectively buy off plan, putting down, say, £2,000, and throughout the course of the build period, it may be 2.5, 3 years, to pay in instalments the rest of their deposit. This is a way a way to assist first-time buyers actually get onto the property ladder. It has other advantages too. It means that they get lots of help from the sales team in terms of 3 newsletters a year. On those newsletters are all the products available from the mortgage shop or banks or lenders. And very often the sales team will pick up a product they think is suitable for a certain young couple or what have you, or anyone that's on the waiting list, and alert them to it and direct them to it. It's also good because when they come to 2 years hence to actually get their mortgage before they move in, they're not then seeking a 100% mortgage. They're perhaps seeking a 90% mortgage, which means that their interest repayments will be lower and they get a better deal. And the multipliers now are incredible as compared with 10 years ago after the last financial crash. It's something that we're scoping. It's something that SOJDC keep a very close eye on. But effectively, in my day when I was buying, and for a very long period, the multiplier was ×4. So if you earn 50,000, you could buy a place and get a mortgage for 200,000. Now there are products available with 6 or 7 times multipliers. And also very much longer terms, if that suits for younger people, if you're the right age, it's the 2-generation mortgages of 40 years. Not saying that people should leverage themselves with debt, but there are more commercial choices now available. as soon as permission is granted, SOJDC will put the adverts out to target those first-time buyers. You know, do you want to move to the waterfront? Are you looking to buy? Are you a first-time buyer? Are your earnings in this bracket? Come and talk to us. The next tranche. So we've got that's for the 50% of the sales on the South Hill and the waterfront. The next tranche will be 20% available to those who want to right size. They'll have to qualify within a certain bracket in terms of the value of the property they want to leave, probably around from 750 to over 1 million. I'm not quite sure where that's being set yet. Interestingly enough, actually, I do know of a couple who lived in Leafy Grooville for most of their married lives, and did move to the waterfront. So to I think one of the Castle Quay flats. So it does actually happen that people may decide to move into town on that. But of course, I understand that for a lot of people, they want to stay in their community. So the right sizing here for the empty nesters is not just available, it's help that's available too. It's for a lot of people, they'll be senior wanting to move out of larger homes. Often we're resistant to change. We'll probably put up with a home that's not suitable for us because we don't want the hassle of selling and buying and all the complications. So we'll put up with the drafts and the fact we've got too big a garden and maintenance, etc. Even though they might want somewhere which is smaller, cozier, maintenance-free in terms of they just pay their annual costs for that, and it's taken care of, so it's attractive and better suited to them. And of course, they free up their home, so we get 2 bites of that cherry. And in the Andium scheme, they'll be given assistance through every step of the way, and I think that will be attractive. They will also be given financial assistance up to a certain limit, depending on the price. Andium will pay their stamp duty, or at least a percentage of it. So that incentivizes the right sizing, and that takes us up to 70%. Excuse me. That takes us up to 70%, and the last 30 is for open market. The last 30% is open market, and amongst those will be second-time buyers, those that have got on the property ladder maybe 4 or 5 years ago, and the house will have appreciated, and they may have bought a 1-bed, and now they want a 2-bed. And of course, it will be the premium ones as you get further up the units, of course, to the penthouses and sea views. Yes, those will be premium ones. Okay, just bear with me. Now, of course, all of that will still be out of the reach of some people, and those people are on the gateway for the home buy product. And I can absolutely assure the Senator and the Assembly that we will exceed the objective assessment recommendations on this product, on the home buy, on the gateway. And we will tailor what is coming down the line that is specifically the point of the new housing and regeneration strategy function, to make sure that we are tailoring what is built to who's on the list and what they require, and we have the time to do it. Andium's latest projection, being cautious and careful not to include sites that have not yet been confirmed, or is 2,500, just over 2,500 homes, up to 2030 over the course of the to the end of the decade. And currently on the gateway, we've got 1,400 plus wanting to buy, 600 plus wanting to rent, and 400 plus wanting to move from, they're already in rental in Andium and they want to move. So on paper, that will satisfy that need. But if as you'll have seen, we've got some certainty now on two important sites, the hospital and the old Kennebec School, coming online 2023 start with the St Saviour's Hospital, not till 2026 or 7 with Le Kennebec. If the waterfront development goes ahead as planned, SOJDC have indicated they will have enough on their plate with South Hill and the waterfront, and it is inconceivable that Andium won't have the lion's share of the Academy and St Saviour's Hospital developments, and will be, the process has to be followed. But that is going to be good. I said I would get certainty on government sites for Andium by the end of this year in my action plan. So there's 2 sites there we've now got certainty on. Of course, the process on relocating the Rougemont School and the whole education requirement provision in St Helier is that process is coming to an end. So we have other sites, the old ambulance station, Lamott Street, Philip Lefevre House, Westway Court, Le Bar Centre, and there are others. So if as we hope, those are earmarked for housing, if we get certainty on that, we could get up to Andium's next projection would take us over the 3,000 mark. I think it's 3,124, something like that. So that we will comfortably, over the course of the next 8 years, we are going to meet the requirement of the gateway. It is I mean, I've been through periods, Senator Ferguson. I think I said when I first stood in 2014 for election, I think one of my sort of bullet points was scrap the SOJDC. So I've been there. I've been through that process too. I've had to go through a process with these 2 sites. Myself, I've got to be honest with the Assembly. I wasn't keen when I opened the Evening Post to learn in, I think it was February or March, of the South Hill development. I wanted a hotel on there, like a Mandarin Oriental or a Hyatt or a Hilton, plus all the accommodation and more that the workers would need to facilitate that, and more. Excuse me again. But no one's building those. No one's building those hotels after the pandemic. So we've got hotel beds are very, very important for this island for our connectivity. We've got brilliant connectivity, but as Matt Thomas from Ports keeps saying, we won't hold on to that alone with just the finance industry who desperately need that connectivity. We need the tourism trade to keep up. So I have been on a journey, and I've taken very seriously the Senator's proposition, and I did support his last proposition, and I'm pleased to see the 15% assisted purchase on those sites. So why am I not supporting him today? I think it puts the plans in jeopardy. And I've looked very, very closely at the plans now. I've looked at the £150 million worth of public realm and infrastructure on the waterfront development. It's interesting that actually the domestic buildings only occupy about 25 or 30%, whether you count the existing Jardin de la Mer and the existing Marina Gardens, gardens above the waterfront car park. So if you count those, it's something like 65% public realm. And if it's a bit cheating to count that because they already exist, it's about 30 or 35%. So there is, a well over half of the whole waterfront site is public realm. And the more I looked into it, the better it appeared to me. There's 3 pools. One is an outdoor Lido, one is a lane pool, one is the flume pool. There is all the roads all the stuff that has to go under the roads, all the stuff that goes over the roads, all the landscaping around the roads, a tree-lined avenue, the new cycle paths. There'll be active ground floors at the bottom of the domestic units where they border the main arterial routes. Where it's interior courtyards or gardens or cycle paths, where they're bordering that, there will be domestic use on the ground floor, and there's a lot of call for that. But the active ground floors in terms of shops will be convenience shops, food and beverage, and not high street shops. So there's no threat to King Street and Queen Street. And
Deputy, I'm afraid I have to interrupt you. Your 15 minutes is up.
Okay. Well, I did ask if I could be considered as a main respondent, as
that request didn't reach my office. I've had a request. We've identified the Treasury Minister and the Environment Minister as main responders, and I said that I would accept 2 main responders, but I haven't heard. I received no request on your behalf. I'm sorry.
So that's absolutely fine. I will leave it there, and I get a second chance to speak on the main proposition, I think. But
you will. Yes.
I'll leave it there. Okay.
Indeed. Does any other member point of clarification? Deputy Gardner, Deputy Abbey, will you give way for a point of clarification?
Yep.
Deputy Gardner.
Thank you, sir. I am recognizing, as everyone else, that we have, at least, we have a huge need for affordable housing. The minister stated that he looked at the areas and looked into the infrastructure. I would like to ask Minister if he looked into the education estate, and specifically to ask if the St. Xavier Hospital development that he mentioned in his speech that was recently allocated for the housing, and I'm welcoming this development generally, is it not coming as against the state's decision, which was made on the 20th of July, by adopting the proposition and directing the government to allocate sites for the primary schools in St. Helier and St. Xavier before any other site will be allocated for any other purposes?
Well, that caveat still exists, I say to the deputy. In fact, once we know that there will be a housing component on the St. Saviour site. That's what we're saying. Interestingly enough, when I got the green light from the Council of Ministers on this, my first calls were to the Constable of St. Saviour and the Constable of St. Brelard, and the Constable of St. Saviour said, "I want a school on it." And I said, well, you're going to be part of this consultation big time, as are the local community. There is a lot of the review into where the school or schools are going in St. Saviour and St. Helier is coming to completion. And I need that certainty, I say to the deputy, because those other sites that I mentioned, the ambulance station, Lamott Street, etc., I can't give certainty on those until the school priority is sorted. But it does still remain the priority because that's the state's decision.
Thank you very much. Yes.
Sir?
Yes?
Might it be appropriate time to propose the adjournment, sir?
Well, I've just had a request from Deputy Ward for a further point of clarification from the Minister, presumably.
It's very quick, sir. I wonder if I can ask the Minister, because you did mention the school sites review, whether the Minister knows of the date when that will come to him and when it will come to the Assembly, and we will know about that. Do you have a final date for that? Forgive me, I know I've been a bit obsessed with dates recently and things coming forward, but it is so important when we talk about these wider debates.
Well, the point of clarification is, are there dates for that?
Yes, sir.
Are there dates for that, Minister?
I don't want to mislead the Assembly. I do know that it's due to hit the Regeneration Steering Group imminently. I think because we had to have an extra Council of Ministers meeting on Monday, it didn't happen. So my guess is at the next Regeneration Steering Group, we will get a presentation on the school thing. That's my guess at the moment.
Very much indeed. Well, Chief Minister, you have proposed, I think, the the adjournment. It's a little early, but I have one person listed still to speak. There may well be others, and then the senator will of course have a right of reply. I will take the adjournment now unless members indicate that they wish to carry on. Would that be indicated in the chat? Very well, the adjournment is proposed. The Assembly stands adjourned until 2:15.